I did. Most of it. Ms. Dudley, did you have something? Okay. All they told me is he has a private attorney, but we don't know who it is.
We were gonna file one, but the portal won't let us.
It just. So who's going to have Connor Prince for the state?
Me.
Okay. Are we ready?
Yes, I am.
Lawrence Elliott for Connor Prince and 25 CF 1620.
All right. Ms. Leone, you're taking this for the state?
Yes, Your Honor. At this time, I'm going to ask for a continuance because after my conversation with law enforcement last night, they told me that they're going to provide me with additional documentation, and based on that, I may decide to file a motion for pretrial detention.
Your Honor, I would ask that we have a bond hearing. He was held based on saying that he met the criteria. He is not charged with life felony, a capital felony, or a first-degree felony in this matter. Even reading the allegations, the alleged victim has a warrant out at this point for the same charges.
Say that again?
The alleged victim has a warrant out right now for the same exact charges.
On the same day or a different day?
The same day, Your Honor.
The same-
They shot at each other in a residential street with witnesses, neighbors around.
No motion at this point has been filed by the state. You know, he's legally entitled to a bond at this point. Outside of that, he's charged with second-degree felony. We would have to go forward on a bond hearing. And even if you read the
Well,
report.
here's the one thing, and it's required by statute, is I have to make sure that your client knows, and I'm sure you've either told him this or will tell him this, Ms. Dudley, is that if I grant him a bond, especially and he uses a bondsman, and he pays that amount of money, and then the state files a motion for pretrial detention, if I ultimately hold him on pretrial detention, then he's potentially going to lose that bond money.
Yes, ma'am.
So it's one of those things I actually put in the statute that's somewhat helpful
Yes, sir.
to explain that to people because unfortunately sometimes these things come up so fast. I think you just had first appearance yesterday.
Yes, sir.
Okay. But a motion hasn't yet been filed.
No, because I'm awaiting that documentation.
I have explained that to him, his position, what he's trying to say, that he does have a job that he's trying to get back to,
Oh,
and
I
family.
understand.
So that's why he wanted to ask for a bond.
Is there any idea why it took so long to get a warrant on this? Happened in October.
I would have to ask law enforcement. I said yesterday.
Warrant was just signed 2 days ago.
Yes,
and he was on first appearance yesterday, so I'm assuming they arrested him within 24 hours of the warrant
Yes, sir, they
being
did.
signed.
Then they arrested him on his way to work, Your Honor. Or he's getting ready for work, sorry.
So Mr. Prince was shot?
Yes, Your Honor.
Both were, okay.
They both were shot.
I got the order setting it for today, but I didn't get to see the
Rob cause.
arrest report
Yes, sir.
until now. I think the issue, Ms. Lanning, at this point, the motion hasn't been filed, and I don't blame you for that. But you get less than 24 hours for the most part to figure these things out. But because it's a second-degree felony and not a life or higher, then there's no mandatory hearing. So I can really only have a pretrial detention if a motion's been filed.
I have 72 hours to file it.
Have any idea if y'all had announced that at first appearance that you would plan to file one? There's no note in the first appearance record. I think, again, the rule has very specific requirements as to if it's filed, if the state announces it's going to file, if it doesn't announce it's going to file. And frankly, I've seen a lot of times at first appearances, if it's basically eligible for a pretrial detention motion to be filed, it's just being automatically set for these, even no matter what the state says. And so without hearing whether or not that was requested, it's kind of hard to make the determination because it's not in there. But I can only assume it was requested. Otherwise, why would we have a hearing set? Why would the order have been signed?
I think if you look at it further, it says he met the criteria, so the judge said it based on the fact that
It's possible.
I don't want to speak, but that has happened, that it gets set on second degree felony just based on the fact that it is a forcible felony listed in the statute, although it is not a life felony or
Dangerous crime, not felony.
yeah, sorry, dangerous crime.
But to be honest, because there's so many different rules
And they seem to get set, sometimes this happens more than, I will hate to say, that it get, even on third degree felonies, just because it's in that list. Usually I've seen when it says the state has asked for, they do write the 72 hours on there, or the state has asked for pretrial detention.
Judge Mason's signature, but it's kind of hard to even see,
Yes, sir,
let
it is.
alone.
It is.
It is?
Yes, sir.
Okay. It's just on my copy, it's very light.
Usually I can tell by the first letter.
Is Mr. Prince on any sort of supervision or probation? Or
No, sir, he's not.
Any reason to believe if whoever was at first appearances asked for, said they were going to file a pretrial? I think it's kind of a issue as to why it says that, but that's what the rule is. So when I read 3.132, what is it? F3, it talks about if a motion's filed at first appearance. Paragraph 4, a state announces at first appearance its intent to move for pretrial detention. Paragraph 5, state does not announce intent to move for pretrial detention. It doesn't say that the state announces it's not intending to do it. It's just if they fail to do it. And the only time you get the extra 4 days is if it's been informed, if the state informs the first appearance judge of that. So without knowing that, I can't really make that determination. What I can do is take a 5-minute recess and go listen to it, and then based on what that says, I'll make the determination.
But
Yes,
as the
sir.
court announced, I can always file it at any time.
I understand. I just don't want to be in a situation like I talked about, where I set a bond, he makes the bond, and then you file it tomorrow, and then we're right back in the same spot. And it didn't really get us anywhere, and he may have spent a good sum of money on a bondsman. I mean, that's his choice if that's what we did, but I'd like to go see that so I can make a proper rule.
Yes, sir,
So we'll
understood.
take a 5-minute recess to
Yes, sir.
do that.
Yes, sir.
He's going to review first appearance, whether or not we
Doesn't want to give me a continuance. That's what he believes we need to do. I have 72 hours to file it. He was arrested yesterday. He was arrested yesterday. So,
Well, yeah, exactly.
I mean, we're gonna,
and they, and I can tell it's,
I will tell you this, though. Unless it's changed since then, Mason is usually pretty good about state, are you going? Well, yeah, or they'll say,
Usually they'll say,
This is what I heard. He's charged with aggravated battery with a firearm, which is not what's in the report. Aggravated deadly weapon is a second-degree felony. Aggravated battery with a firearm can be elevated to a first-degree felony if it's charged that way, which it's not in the arrest report. I believe that still means by information. But that can only be done if the use of the firearm is not basically part of the initial charge. For example, if it was aggravated battery due to great bodily harm, but that's not what it's charged. It's charged as firearm, or as deadly weapon. So I don't think it should have been treated as a first-degree felony, at least not yet. There's the potential there, obviously, with how the state files it. But the issue is, at first appearance, the judge said it's a first-degree felony, so therefore it must be a pretrial detention, and the state never had an opportunity to say, we're going to file, because they were told it was automatic. Because of that, I'm going to give the state an opportunity to file that motion. It's 4 days, starting yesterday. So it's 3 days from today to file your pretrial detention motion.
Yes, Your Honor.
If it's filed, I'll special set it for Tuesday, because
Yes, sir.
Monday's a holiday. But I think I said this earlier this morning, it seems like half the time we're just spending on fixing things that just are a little bit off. And unfortunately, like I said, I found an answer to our question and found another question. So that's what I'm going to do, because I believe the state wasn't given the opportunity to even say they're going to file the motion or not. So I'm going to give 4 days from yesterday, so it'd have to be filed within the next basically 72 hours or so. If it's filed, I'll hear it at 12:30 on Tuesday. We have a docket that day. Just be prepared to do that at 12:30.
Yes, sir.
If it's filed, otherwise, if it's not filed within the next 72 hours, then it'll just go to first appearance and have his bond set there.
Yes, sir.
Yes, Your Honor, thank
Everybody
you.
understand? I think this is why we just need to make some amendments to our first appearance forms since the rule came out, because they haven't been adjusted since they were adjusted when the statute came out, but not the rule. And obviously, if the state decides it's not going to be filing,
I'll notify the court.
notify the
Defense
court
lawyer.
as well as Ms. Dudley, so we can potentially get it on the first appearance docket sooner.
Yes, sir. No, that's all I have.
All right, thank you, Ms. Dudley. If a motion's filed, it'll be Tuesday at 12:30. Well, it'll be on our docket at some point on Tuesday. And Ms. Leone, if y'all decide to file a motion, if you could send a copy to Ms. Dudley into my office,
I always do, yes, Your Honor.
just so we can be prepared
Yes,
for
yes,
Tuesday.
Sorry.
Oh, you're fine, yeah.
All right, Mr. Mannix, who do we have?
Your Honor, this is Miss Bianca McDonald. Forgive me, I don't have a case number handy, but she's set for today.
The pretrial detention, it's 25 CF 1602.
Thank you, Your Honor. Defense is asking for a continuance in this matter, Your Honor, to next week.
State have an objection
No,
to
no
that?
objection.
All right.
Then the state is not seeking pretrial detention.
It'll be a bond hearing, Your Honor. The reason I'm continuing this matter is because there's potential information that she can provide, my client can provide to us that I just don't have access today. Discovery materials, Your
Yeah,
Honor.
I understand. I'm just trying to think on how we can handle this. If it's just going to be a bond hearing, that we could put that on Tuesday as well, and then maybe in the afternoon. I just don't want to wait all the way till Thursday if we don't have to, since the state's
Yeah, no,
not
certainly.
going forward on it.
Certainly. You think? Okay, Your Honor, let's set it on Tuesday. I think I should be able to get everything squared away by then.
For 1 o'clock Tuesday. And if you get what you need, Mr. Maddox, and you talk to Miss Leone, and y'all come
I
to some
certainly
sort of
will.
an agreement, send me an order, or if it's tomorrow afternoon, I may be just asking all of my emergency or time-sensitive things like that to go to the duty judge, because I may not, I definitely won't be in the office, but I won't be able to handle anything like that.
All right, that's fine, Your Honor, thank you.
But I still want it to get done for you if y'all have an agreement.
Yes.
All right, so that's good, save you a couple days.
Okay. All right, did we have anyone else that was supposed to, we already handled Presley and then Mims is in the south. All right, so are we ready for our 1:30, please? I guess we're early now. Put it on pretrial detentions for next Thursday, just in case nothing happens for Tuesday. It should, because he should go into first appearance. If not, I don't think Miss Dudley's gonna let it fall through the cracks. As you can see, and probably hear by my being out of breath running back here, I was not able to over the lunch break.
I cannot.
But I did ask my assistant to forward the motions over to our staff attorney's office so they can start looking at it and maybe get a better idea on how quickly we can have it heard. With 13 pages of legal argument, it's kind of hard for me to make a snap decision on that. So I spent about 30 seconds on it, making sure it got forwarded to them. But that's still, probably 5% of my lunch break.
We can handle Mr. Tommy, Your Honor, that plea.
Yeah, I guess if we can handle some of those from the morning that we held over. Who was handling Grimes this morning?
Sorry,
Or
Your Honor?
Lively.
Mr. Williams was finishing that one up, Your Honor. I initially
I
handled
just
it.
got emailed a 9-page letter she wrote to me.
All right.
I'm assuming it came in before today's date, but it just got sent to me. Can you print one for me? For some reason, I don't seem to have one. I didn't remember seeing it yesterday. Yeah, I think that's probably when I got printed out, the updated ones, but. Is that an update since this morning when we handled a couple of them?
All right, Your Honor, this is Mr. Kami before the court in 24 CF 1657. Your Honor, this plea agreement would also resolve his misdemeanor charges, which are a basis for the violation of probation in 25 MM 2520. I have contacted Mr. Flowers and confirmed that this is the agreement she wishes to reach.
Miss Flowers.
Yes, Your Honor. Jennifer Flowers?
I thought you said Mr. Flowers.
I hope not.
He did? Okay. Verification was you said Mr.
Miss Flowers?
That's why it threw me off. Because
No. All right, thank you. May I approach, Your Honor?
Yes. I feel it's going to be one of those afternoons, Mr. Maddox. Well, let's see. All right, so You know, I always have a question.
Yes, Your Honor, of
On
course.
the misdemeanor case, the 25 MM 2520,
Yes, Your Honor.
it's withhold of adjudication, time served, show proof of a valid driver's license and registration.
It was part of the plea agreement, Your Honor. I had no issues putting
If
it
he
in there.
doesn't do that, what do I do?
I understand there's minimal teeth to it, but, in good faith, I wanted to put that in there because the state requested it, Your Honor.
And what's the timeline?
I don't think I'm going to D6 a condition of get a license.
I
Kinda
understand.
seems like we're chasing our tail at that point.
It was a standard condition in plea agreements in county court, Your Honor. I'm always happy to oblige the state on that.
I thought he said proof
Proof of registration and license, yeah.
What I'm saying is-
eligibility.
If he doesn't do it, and he's not on probation for that.
Correct. There's not really again, it's intended to just push them in the right direction, Your
No,
Honor.
I understand. I'm not being critical. I just want to make sure that we don't do things that don't really get us anywhere. Where's Mr. Kami again? All the papers. Oh, I got it. I'm just kidding. I have like 100 right here from yesterday. All right, Mr. Kami, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Can you state your full name and date of birth, please?
Timothy Jacob Kami, 3198.
All right, Mr. Kami, you're here in 24 CF 1657, which is a violation of probation. You're also here in a county court case, we're going to handle for you today, 25 MM 2520, where you're charged with drive while license suspended and no or improper vehicle registration, which are second-degree misdemeanors punishable by up to 60 days in jail, and possession of drug paraphernalia, which is a first-degree misdemeanor and punishable by up to 1 year in jail. Do you understand that?
Yes, Your Honor.
Okay. I've been handed a plea and sentencing agreement that calls for you to admit your violations of probation in 24 CF 1657, revoke and terminate that probation, but with new terms of supervision to be 1 year community control, followed by 2 years of standard probation, 50 hours of community service. What is pay $1 per month into the first step funds?
It was part of the original order in his probation terms, Your Honor. The state and I reached an agreement for him to complete all original terms. That was one of the conditions placed in the order, Your Honor.
All right, just hadn't heard of that before. All
I
right.
had not either.
Complete anti-theft course, waive cost of supervision, adjudication of guilt. All supervision terms will be concurrent with those counts in the felony. $150 cost of defense, $100 VOP fee, and then in the misdemeanors we talked about in counts 1 and 2, withhold of adjudication, time served, show proof of valid driver's license and registration, $300 in court costs, $50 cost of defense, and the state will dismiss count 3, which is the paraphernalia. Is that what you want to do today, Mr. Kami?
Your Honor.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Did you understand and sign the agreement?
I do.
Did you, are you satisfied with your lawyer's advice and representation?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No,
Has anyone forced, pressured, or threatened you in any way to enter this plea?
Your Honor.
Has anyone promised you anything in return for your plea?
No.
You understand that if you admit your violation of probation in the 24 CF 1657 case, then there won't be an evidentiary hearing where the state would have to prove that you violated your probation. And do you understand that if you enter a plea in 25 MM 2520, there won't be a trial of any kind and you're giving up your trial rights, which are listed on page 2 of that agreement that you signed? Okay. And you understand you're waiving any potential defenses you have to any of these charges?
I do.
All right, and do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right, as to the VOP in 24 CF 1657, what is your plea? Are you admitting or denying your violation of probation?
Admitting.
All right, and in 25 MM 2520, what is your plea to the driving while license suspended and no or improper vehicle registration?
No contest.
All right, I'm going to accept your admission to the VOP and the no contest plea as freely, voluntarily, and knowingly given. In 24 CF 1657, revoke and terminate your previous probation, give you a new term of supervision to be 1 year community control, followed by 2 years of standard probation, 50 hours of community service work, pay $1 per month into the First Step funds, complete anti-theft course, waive cost of supervision due to the fact you're represented by the public defender, adjudicate you guilty, which I believe you were already. All
Correct, Your Honor.
supervision terms are to be concurrent between each of the charges in that case. $150 cost of defense, $100 VOP fee, and then in the misdemeanor 25 MM 2520 on counts 1 and 2, withhold adjudication time served, show proof of valid driver's license and registration, $300 in court costs, $50 cost of defense. State have an announcement on count 3.
State dismisses country.
Okay. Dismissal of the paraphernalia. All right, since you're going to be on supervision, Mr. Kami, I'm going to go have you talk to supervision before you leave. I will need his fingerprints because of the driving while license suspended charge on the misdemeanor, even though it's a withhold.
All right, thank you, Your Honor.
All right, thank you. Let's see, community control. All right, Mr. Kami, I didn't say this yet, but you have 30 days to appeal the judgment and sentence of the court. All right. Mr. Kami, on the misdemeanor, those costs, you'll have 90 days to pay those or set up a payment plan. Otherwise, they'll be sent to judgment.
Appreciate that, Your Honor.
All right. Did we have anything else held over from the morning?
Not for me, Your Honor.
Judge, I've got a couple of cases, but I'll still need to speak with those folks. So what I'd ask is that we pass it until after arraignments.
Okay. Everyone ready for start the 1:30 arraignment docket since it's officially 1:30?
Yes, Your Honor.
Okay. No, if you would just want to call a docket based on who's not in jail, because my doesn't seem to be marked. Armstrong?
That's mine, Your Honor.
All right. This is John Armstrong, 25 CF 1367, represented by Mr. Maddox, who's approaching.
Yes, Your
Oh, I'm sorry, there's also 25 CF 1368.
Yes, Your Honor. This is Mr. Armstrong, Your Honor. We will enter pleas of not guilty at this time in both cases on all counts, Your Honor. Ask for 15 days for any preliminary motions and trial by jury.
Do you have a copy of the informations in each case?
Should, Your Honor.
Well, you should, but
Grab my stack here. Yes, Your Honor, I do. And he's been provided a copy of each.
all right, you want the October date?
Please, Your Honor.
All right, Mr. Armstrong, you're going to come back for your next, or your first pretrial conference date. That's going to be October 27th at 1 p.m. So all the ones you're skipping are in jail? Okay. All right. Madeline Cassidy? Say again. All right, are you Miss Childs?
Yes, sir.
Jennifer Childs?
Yes, sir.
All right. Mr. Williams, you seem to be on that one. Well, my docket says Mr. Williams.
Yeah, that'll be me, Your Honor. I do have a copy of her information. I'm providing it to Ms. Childs now. At this time, Your Honor, we'd enter a plea of not guilty, request 15 days for any pre-arraignment motions, and trial by jury.
All right, Ms. Childs, we'll have you come back October 27th at 1 p.m. for your pretrial conference.
Yes, sir.
Thank you. Stay in touch with Mr. Maddox. Well, let me go back to the one. We don't have Cassidy. Mr. Maddox, do you have any contact with her?
Check my notes, Your Honor. I did file a waiver for one client today. I know that for a fact, and it may very well may have been her. Give her a quick look up here.
Waiver of appearance was filed on 8/22.
Okay, perfect. I'm showing the same as well, Your Honor.
Information was filed. We'll put Cassidy on October 27th, 1 o'clock.
Thank you, Your Honor.
Well, let me just, on Cassidy, I'm going to need you to enter the plea of not guilty because it looks like just a waiver of appearance was filed, so.
That's
technically
correct,
You
Your
haven't
Honor.
pled not guilty yet.
Do you want me, would the court prefer I file a written plea of not guilty just to track it? Okay, then I'd enter a plea of not guilty this time, Your Honor. 15 days for any pre-arraignment motions and trial by jury.
All right.
Thank you, Your Honor.
All right, who is next? Cordova.
Do you have an offer in this case? Yeah.
Yes, the state's offer in this case is an adjudication of guilt, 2 years probation, and the 10 days of mandatory Okaloosa County Jail.
Okay. We'll enter a plea of not guilty at this time, 15 days for any pre-arraignment motions and trial by jury.
All right, Mr. Cordova, come back for your pretrial conference on October 27th at 1 p.m. Stay in touch with Mr. Maddox. Georgia Daniel, 25 CF 1446. Mr. Maddox is your assigned lawyer.
Yes, Your Honor. At this time, we'll enter a plea of not guilty, 15 days for any pre-arraignment motions and trial by jury, Your Honor.
All right, Ms. Daniel, come back for your pretrial. It's going to be October 27th at 1 p.m.
All right, thank you.
Just note, we are going to be transferring this one to the south end.
Oh.
She had a PTI with a plea down there, and so this is going to go and accompany that case, Your Honor.
Is that
Where's the south end?
the way y'all usually do things? It's a PTI with a plea, so it's not a VOP.
Correct, Your Honor. So
'Cause usually a VOP would just come up here.
Yes, Your Honor. So in that case, I talked to the ASA on there. Only the judge that took the plea, I guess, is supposed to be the one that takes
Makes
the
sense.
sentence.
All right. Does that case have a new date yet?
I don't know if it has a date yet, Your Honor.
See if we can find it. Sorry, my system just started going amazingly slow. Yours too?
It is. It's 24 CF 1913, Your Honor.
I'm sure I can find it. I just want to find out if if it's already been recalled. Doesn't look like it. Do you have a date to put it on down there, Mr. Sheik?
I do
I mean,
not.
because it's just not on here. I don't want to try to figure out a date for her and then give her the wrong date, and then just,
Yes, Your Honor. I don't know what the date would be down there.
I think, what's that case that we had that was scheduled for two?
I'm not going to play guesswork with it. So, Ms. Daniel, I'm just going to give you the same date I gave you, October 27th, 1 o'clock. Now, if the state transfers it, you're going to get some paperwork saying go to Fort Walton with your other case, since that one's most likely going to be violated out of your pretrial intervention agreement because of the new charge. But I don't want to get too far, cart before the horse type stuff, because I don't want you to end up missing a court date. So until you hear otherwise, October 27th, 1 o'clock, back here in Crestview. Douglas Dawsey.
Check my notes and see if we've made any contact with her, Your Honor. Him.
Douglas.
Apparently I can't get gender right today.
Careful.
He kept doing it.
I don't have any information at this time, Your Honor.
All right, I'm looking at the initial arrest report, shows today's date at 1:30 in Crestview. State? All right, be a capias, no bond. If Miss Dawsey shows up, recall it.
All right, thank you, Your Honor.
Afternoon.
Afternoon, Mr. Ferguson. Looks like you don't have an attorney assigned, so.
Negative, Your Honor.
All right, so you're here in 25 CF 1502. Was it information given over? No information filed?
You want me to bring it up first?
No, have you filed one yet?
We have filed one, yes, Your Honor.
Just hasn't been processed?
My guess is
I
yes.
see it just to make sure it confirms with what I've got here. Signed a couple of days ago. All right, Mr. Ferguson, you're charged with counterfeiting license plates, which is a third-degree felony. Do you understand that?
Yes, Your Honor.
All right, are you going to hire a private lawyer, or would you like me to appoint you a public defender?
Appoint a public defender, please.
All right, are you currently working?
I am.
All right, about how much do you make a month?
8,000, Your Honor.
8,000? Do you have any dependents?
I do.
All right, I don't think you qualify.
Yes,
How
sir.
many dependents do you have?
2.
2. No, I don't think you're anywhere close, actually. So the limit is basically twice the poverty line. So I wouldn't be able to appoint you a public defender. You feel free to, you can go down to the clerk's office and fill out the indigency paperwork, which has a little more in-depth detail about how much you make and assets and debts and things like that. But based on what I've heard, I don't think I can appoint you one. All right. So what I'm going to do is enter a not guilty on your behalf. I'm going to give you a court date of October 27th at 9 a.m., which is when we have private lawyers or people who are unrepresented. If you hire a lawyer, obviously they can set things up for that court date and be here for you.
And Your Honor, if I may, the state's offer in this one is, the current offer is a pretrial intervention agreement,
Okay.
is a possibility.
Is a possibility.
Well, no, I mean, it's,
Okay. All right, so Mr. Ferguson, what they're potentially going to offer you is something called pretrial intervention, which I'm not going to try and encourage you to do one thing or the other, but just to give you some quick information. That's not advice, because I can't do that. It's an agreement that you would do whatever on that agreement, basically staying out of trouble, paying some costs, and whatever else is on there. If you complete that, the case would be dismissed. Is it with a plea or without a plea?
it would be without a plea. Your Honor.
Without a plea, which means you wouldn't even have to enter a plea. It's basically what we call a diversion program. So you have one written up.
I do not yet.
Okay.
I wanted to speak if the defendant had an opportunity, based off of the statements in the police report, there may be some extenuating circumstances. And so I'd be curious to know about those before we came to a final agreement, Your Honor.
Okay, well, unfortunately, I'm not sure our arraignment's the time to really talk
Yes, sir.
about those particular facts, but
Yes,
I'm going to
sir.
put you on that court date, sir, of October 27th, 9 a.m. Again, you're certainly welcome and have the right to talk to another lawyer and see what you should do about your case.
Yes, Your Honor.
All right, thank you, Mr. Ferguson. We'll see you back on that date. Oh, he said Jimmy Henderson.
Judge, I believe it's Jimmy Dean Henderson. Deal?
Jimmy
Okay,
Deal
go ahead.
Henderson.
Step right on that. Okay.
All right, 25 CF 1431, driving on a permanently revoked driver's license. Has information been filed?
Yes, Your Honor.
Judge, I have a copy, and I've given it to the defendant. I'll enter a plea of not guilty on his behalf, 15 days for any pre-arraignment motions, and demand trial by jury. Mr. Henderson, you're going to need to make an appointment to come see me. Yes, sir.
All right, stay in touch with your lawyer, Mr. Henderson. We'll see you back on October 27th at 1 o'clock.
Thank you, Judge.
All right, thank you.
Gary Hudson?
There you go, Gary. Judge, this is Gary Hudson. Same situation. I've handed him a copy of the information. One has been filed. I'll enter a plea of not guilty on his behalf, 15 days pre-arraignment motions, trial by jury.
All right, Mr. Hudson, October 27th at 1 o'clock will be your next court date. It's a pretrial conference. Stay in touch with Mr. Williams.
Yes, sir.
Thank you.
Thank you.
Jeffrey Johnson?
There you go, Mr. Johnson. That's your copy. Judge, I've got information on Mr. Johnson. I've tendered it to him. Enter a plea of not guilty, 15 days pre-arraignment motions, trial by jury.
Is there a plea offer on the case, Mr.?
I'm not taking no plea offer.
I would need a second to prepare that, Your Honor.
Okay, well,
I-
you don't have an offer?
I do not have an
Okay,
offer.
that's fine. I'm just asking if they happen to have one
As
available.
soon as possible, too.
Yeah, you call the office and tell them you need to make an
Can I call
appointment
it?
with me, and they'll do that for you.
All right, Mr. Johnson, October 27th at 1 p.m.
Thank you, sir.
Marcus Jolly?
Hang on a second, and I'll get you one, okay? Judge, Mr. Jolly's case was no pros.
That's correct.
All right, Jolly was Nalprost.
Sean Jordan?
That was an out-of-state or a fugitive.
There it is. Let's check. All right.
Lewis?
All right, Sean Jordan was released July 31st.
Then, in that case, the state would no prosecute, Your Honor.
No pros, 25 CF 1509. 25. Who do you have, Mr. Williams?
Judge, I believe this is Kalani Lewis.
Okay.
Is that correct, ma'am? Okay.
25 CF 1530.
If I don't have an information in front of me for her, and when I checked yesterday, one had not been filed.
State.
1 second, Your Honor. Your Honor, do you want to review it?
If there's an attorney, I don't think I need to review it.
Thank you. Is this my copy?
Yes.
All right. Ma'am, I'm going to give this to you. This is the formal charge. I'll enter a plea of not guilty on her behalf. Request 15 days for pre-arraignment motions, trial by jury.
All right, Ms. Lewis, October 27th at 1 PM is your pretrial conference. Come back on that date.
Yeah, make an appointment, come in and see me, okay?
All right, Mr. Sheik, on James Dale Leon, 25 CF 1419, was an out-of-state fugitive. He was released on August 2nd.
And the state will no process, Your Honor.
Okay. You said Mr. Nopes is here?
No, he's not.
Oh, he's not here.
Okay, Ms. Louise.
Is there an information on McClellan?
Yes, I'm sure I filed it. Yes, Your
sorry.
Honor.
Yes, Mr. Noble.
It was filed on July 14th.
Does anybody have a copy of it for Mr. McClellan?
I don't have a copy, I have the original.
If you have the original, wasn't the original filed?
I think they e-file it. It's got the,
Found one? All right, Mr. McClellan, you've been appointed a private lawyer named Marty Nopes.
Yes, sir.
He's not here for you today, so what we're going to do is enter a plea of not guilty on your behalf. I'm going to have you come back on October 27th at 9 a.m.
Yes, sir.
And they're going to print out a copy of the charging document for you in just a second. And just maybe that Mr. Nopes didn't get notice of today's court date. McWilliams?
So I'm not positive, Your Honor. There's a case in the South End this is going to be transferred to, so I don't know if maybe she's in custody. Not at all? Okay, then the state would ask for a capias in this case, Your Honor.
Can't open any of the documents. Notice form create. As in Alabama. Looks like she was released, but there wasn't a Escambia County hold. I don't see her in the Escambia County Jail ever. Maybe it's at Escambia, Alabama. I don't know. But based on what I've seen, I haven't seen a reason why she shouldn't be here. So I'm going to do a KPS with no bond.
On it, Mr. Moore. Mr. Moore, that's your copy of the charges. Judge, this is Jerome Moore, 2025 CF 1406. I'll enter a plea of not guilty on his behalf, 15 days for pre-arraignment motions, trial by jury.
All right, Mr. Moore, come back on October 27th at 1 o'clock for your pretrial conference. Stay in touch with Mr. Williams.
Thank you, Judge.
Zaleski. Your last name, sir? All right, come on up, sir. All right, this is 25 CF 1417. All right. Sir, you're charged with felony battery, which is a third-degree felony. Can you afford an attorney to represent you? You need an interpreter? Ma'am? Well, does he need an interpreter?
Can you hear him?
Well, but if he doesn't under... Does he work? No, he's on. Okay, then I'm going to appoint the public defender's office to you. Is that going to be you, Mr.?
Nico.
All right.
All right, Judge, I'll enter a plea of not guilty on, well, do we have an information file? Oh, you did? Okay. I'll enter a plea of not guilty on his behalf, 15 days pre-arraignment motions.
Can you write his court date on it for him? It's going to be October 27th at 1 o'clock. Ma'am, can you come up for just a quick second so we don't have to have you shout answers back at me? What is your relation?
I've helped him for years. We're
Okay.
just really good friends.
Does he need an interpreter? Or is it more of a issue with the health?
It's more of an issue with his hearing,
Okay.
and because he's had a couple of strokes, he's just not good at anything like.
I'm just trying to figure out if we should try to get an interpreter for a different language for him.
Yeah, I don't think that's gonna make a whole lot of difference, because that language is so old to him that he doesn't really remember that very well either.
Okay. I appreciate that. I'm just trying to see if we
Thank
need
you.
more help for him at his next court date.
Thank you.
All right, October 27th at 1 o'clock will be his court date. Have him stay in touch with Mr. Williams to see
Thank
what
you.
y'all can do to figure out what's going to happen next.
Okay,
All
thank
right,
you very much.
Matthew Murphy. Why does the docket have all the wrong public defenders listed?
He's almost done.
Ma'am, if you need to talk with me further, I'll have to step out in just a minute.
Thank you, Your Honor.
Thank you.
Come on, sir.
This is Matthew Murphy, 25 CF 1433.
Yes, sir. Judge, when I checked yesterday, I didn't see an information had been filed. Has one been filed, Madam Clerk? It's under Ms. Rivers' name. Oh, that
Might
she
be in her
might
stack.
have
I put your stuff in,
it. Okay, all right. So we do have a formal charging document. Judge, I'll enter a plea of not guilty on his behalf, 15 days for pre-arraignment motions and trial by jury.
All right, October 27th at 1 o'clock. Stay in touch with your lawyer, Mr. Murphy.
All right, there you go, sir.
next is
right, your name, sir?
Gregory Siegel.
All right, Mr. Siegel, you're here in 25 CF 1538, charged with driving while license suspended with prior convictions, which is a third-degree felony. Are you going to hire a lawyer? You want me to appoint you one?
I need a lawyer. I need a public defender.
Okay. Are you currently working? All right. When's the last time you worked?
2015, I'm filed for disability right now.
Okay. All right. We're going to have you fill out the application down on the first floor at the clerk's office before you leave, but I'm going to go ahead and provisionally appoint the public defender's office to represent you, Ms. Rivers.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
All right. We'll see you back on October 27th at 1 o'clock, Mr. Siegel.
You need to fill out a form in the clerk's office to get us appointed.
Shemaya Smith.
Just go to the clerk's office and say I need an attorney.
Smith, Shemaya Smith.
Your Honor, just to save you time looking, in 25 CF 1598, based off of the victim's request, the state is going to no pros this case, Your Honor.
Appreciate you finally jumping up.
Texas Shannon Stell or Steele.
It's 25 CF 1425.
Your Honor, we are going to enter a not guilty plea and request trial by jury.
October 27th at 1 o'clock is your pretrial conference. Is it Stell or Steele?
Still.
Stell. Stay in touch with Ms. Rivers, who's your appointed lawyer, and we'll see you back on that date. All right, this is 25 CF 1404.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
Mr. Willingham, October 27th at 1 o'clock for your pretrial conference. Stay in touch with Ms. Rivers. Wilson, 25 CF 1511. Ms. Rivers, y'all have an information?
Yes, Your Honor, we do. We're going to enter a not guilty plea and request trial by jury.
Mr. Wilson, October 27th, 1 p.m. is your pretrial conference. Stay in touch with your lawyer. Be back on that date.
First one's going to be Charles Boykin.
All right, Charles Boykin, 25 CF 1524 and 25 CF 1525. Mr. Maddox.
Yes, Your Honor.
Y'all received an information?
That one right here, Your Honor.
Okay.
Here we go, Mr. Boykin, that's your charging document, okay? Your Honor, at this time for Mr. Boykin, we'd enter a plea of not guilty, ask for 15 days for any pre-arraignment motions and trial by jury.
All right, Mr. Boykin, we're going to see you back on October 29th at 9 o'clock.
Is this the one you emailed me about, Ms. Barrican?
Yes.
Okay. October 29th.
Carpenter.
All right, Richard Lee Carpenter Jr., 25 CF 1405. Received an information, Mr. Maddox?
I believe so, Your Honor. Yes, Your Honor. There's your copy of the information, okay, Mr. Carpenter. Your Honor, at this time for Mr. Carpenter's case, we'll enter a plea of not guilty, ask for 15 days for any pre-arraignment motions and trial by jury.
All right, October 29th at 9 a.m., Mr. Carpenter is going to be your pretrial conference.
Thank you, Your Honor.
Watch me for.
Charging document. This.
Thank you.
Thomas Thorpe.
or afternoon, I guess now.
Twenty-five CF 1528, Thomas Drew Carr.
Yes, Your Honor, we do have a copy of the information. I'm providing that to Mr. Carr now. Your Honor, at this time, we'd enter a plea of not guilty, ask for 15 days for any pre-arraignment motions, and trial by jury.
Mr. Carr, your pretrial conference is going to be October 29th at 9 a.m.
See, okay.
Raymond Clary?
Your Honor, this is Mr. Raymond Clary before the court in two cases, 25 CF 1332 and 25 CF 1331.
What are we doing with Mr. Clary?
Your Honor, we're going to enter a plea of not guilty, ask for 15 days for any pre-arraignment motions and trial by jury. I do have a copy of the information in both cases, Your Honor.
All right, Mr. Clary, next court date's going to be October 29th at 9.
Come talk to you, okay?
Yes, sir.
We still have the case from yesterday?
I believe we might, Judge. I indicated that he was coming in for arraignment on 2 other cases.
Okay.
My intention is just, yeah. just to
25
have it
CF
craft.
601, that's the arson charge. Put everything on October 29th?
Yes, sir.
Yes, Your Honor.
All right, Mr. Clary, October 29th at 9 a.m. for all 3 of your cases.
Yes, sir.
Thank you.
Thank you, sir.
Isaac Dumas?
I'm good.
Isaac Dumas, you said?
All right, it's 25 CF 1557.
Yes, Your Honor. Your Honor, I'm providing Mr. Dumas a copy of his information. Your Honor, at this time, we'd enter a plea of not guilty, ask for 15 days for any pre-arraignment motions and trial by jury.
And Your Honor, the state is going to be transferring this one to the south end. He's got many cases down there already.
All right, do y'all have a date for that?
I do not have a date.
All right, well, I'm going to put him for October 29th at 9 a.m. for us. If it gets transferred, then he'll get a new date with them.
No, you'll get a new one.
Probably going to be October 15th, but I don't want to say for sure.
October 29th, you said, Your Honor, you were leaving it?
Yes, it looks like his other case is in front of Judge Clark
Yes, Your
on
Honor.
October 15th.
Okay.
But until it gets transferred, we'll keep this court date, but I expect it'll be sent over by then.
Understood. So the 15th and the 29th for now, but the 15th most likely.
He has
Yes, sir.
25 CF 1152, which is basically the same charge.
All right, thank you, Your Honor.
Mr. Carter Maria?
We did air yesterday, right? Did phone earlier.
Mr. Greer. I'm doing okay. How you doing?
There's no information.
Okay. I've been told by the state there's no information filed at this time, Your Honor.
The state is not filing an information on this case, Your Honor. We aren't dismissing it at this time. We do need to follow Marcy's law before we do that. However, the state is not proceeding with this case at this time.
When you might have a decision on that?
I should have quickly. The decision to not proceed with this case, we just have to follow Marcy's law first before. But if you want to set it to an earlier time, Your Honor.
Does he have anything else holding him?
He does. There are a lot of cases on the south end. I believe, yes. Yes. There's several VOPs and.
Okay. What's my next arraignment date? I don't want to do the 4th. All right, I'm going to put it on the arraignment date for September 25th at 1:30. The state should be
Yes, Your Honor.
in a position to make a decision well before then. Looks like you've got Travis Gates as your lawyer on the south end. Do you understand that, Mr. Gurria? Have you talked to him before?
Yes, sir.
Okay. Obviously, if you resolve your cases down there, and I'm not sure if you even have a bond set on this case. Looks like you do have a bond on this case, but Let's make a quick decision on that one way or the other, Mr.
Yes, Your Honor.
Sheik.
We'll figure it out.
Irvin Gasson?
Mr. Gaston?
Yes, 25 CF 1428.
Perfect. All right, here you go, Mr. Gaston. This is Gaston or Gaston?
Gaston.
Gaston. All right, sir. That's a copy of your information, okay? And Your Honor, this is Mr. Gaston. He's before the court in 25 CF 1428. We'd enter a plea of not guilty at this time. Ask for 15 days for any pre-arraignment motions and trial by jury.
I was just going to say, if he's interested, the state is willing to offer a plea to just the petty theft, 1129 probation, plus some of the other minor stuff.
Recharging as a, okay, yeah, first degree. Okay, I'll talk to him about that. Yeah, I'll talk. Do you want to talk about that?
I'll let it go ahead.
Well, he's going to have to talk to you about it and write up some paperwork. We'll bring you back later this afternoon.
Yeah, I'll come talk to you in just a few minutes. Yep, yes, sir. All right, thank you.
We handled Guzman Arredondo. It's from this morning.
Laura Oriana?
That's all I have this morning, Your Honor, or this afternoon, Your Honor.
Well, are you going to go talk to?
Yes, I am,
Gaston?
certainly.
Okay. All right, Mr. Williams.
Yes, sir. I met with Mr. Orellana before.
Is there an information filed?
The information has been filed. I'm going to enter a plea of not guilty on his behalf, 15 days for any pre-arraignment motions, and demand trial by jury.
All right, it'll be October 29th at 9 o'clock for your pretrial conference, sir.
Okay. All right, there you go, sir.
25 CF 1521.
Hey, Maria. Judge, I'm going to enter a plea of not guilty on her behalf, request 15 days for pre-arraignment motions, trial by jury. There's a violation of probation that should be tracking along with this. Well,
All right.
maybe I'm wrong. No, there isn't, Judge. I just have the one file.
October 29th at 1 o'clock will be your pretrial conference, Ms. Leckler.
Okay, there you go.
Trayvon McLaughlin?
Judge, on Mr. McLaughlin, has an information been filed? When I checked yesterday, one had not.
I have it here.
Trevante McLaughlin.
Oh, it was filed yesterday.
I'll enter a plea of not guilty on his behalf then, 15 days pre-arraignment motions, trial by jury.
You have a copy of that, Ms. Leone, because the
No, I
clerk
can
doesn't
get
have it
one.
either.
I can get one.
All right, Mr. McLaughlin, they're going to get you a copy of that information, but your next court date's going to be October 29th at 9 a.m. for a pretrial conference.
Once I get discovery in, I'll come out and talk with you again.
We did McSweeney, right? Oh, that's one we're doing later? Okay.
Yes, sir.
Who's next? Who's next?
Settle, Melinda Settle.
All right, Melinda Settle.
Okay.
Your Honor, this is Melinda Settle. She's before the court on 25 CF 1486. We have received a copy of the information. We're going to tender a not guilty plea and request trial by jury.
All right, Ms. Settle, we'll see you back October 29th at 9 a.m.
I didn't do nothing wrong, though.
Well, that's what we're.
Ms. Settle.
But I didn't bring up the wrong vote. Honey, I didn't bring up the wrong. I went into the bathroom and got a toothbrush. That was it.
You had Schaffner before?
Yes, Your Honor, we had Mr. Schaffner yesterday. Your Honor, I acknowledge receipt of the information. I'm going to tender a not guilty plea, request trial by jury.
October 29th, 9 o'clock.
Your Honor, this is Amy Sturgeon before the court. We acknowledge receipt of the information. We're going to enter a not guilty plea at this time. The state has made an offer that I do want to make her aware of, but there's a couple of things I got to go over with her. So if we could pass her for later so I can see her in the attorney interview room.
Okay. Ms. Sturgeon, she's going to come talk to you, and we'll bring you back out to court in a little bit. Thank you. Settles, not subtles.
Right. I have both.
Good for you. All right. Robert Settles, 25 CF 1467.
Your Honor, this is Mr. Suttles. This is a copy of the information. I'm handing it to him now. He is another one, Your Honor, that the state has conveyed an offer that I need to address with him. And I would ask to pass the case for a few minutes, but at this time, I'll enter the not guilty plea.
Okay, Mr. Settles, she's going to come back and talk to you in the interview room about your plea offer, and then we'll bring you back if that's what you want to do. Is that everyone? Who's this? Wims. I don't have that one. Wims. All right, Mr. Anthony Wims?
Yes, Your Honor.
Junior?
Yes, sir.
I'll just make sure I got the right person. 25 CF 1401. He's listed as out-of-state fugitive. Do you have anything else holding you here, Mr.?
No, Your Honor.
Let me just double check.
Yes, sir.
Who's supposed to come pick you up?
I was supposed to be in Chattooga County, Georgia.
Did you resolve your
Yeah, misdemeanor? Yes.
misdemeanor?
Yes, sir.
Because it's showing open, but I can see your fingerprints were taken. It looks like you pled out.
They gave me 30 days time, sir.
Okay. So that may be the delay. It's just getting you to 30. Oh, you're probably well past 30 days, right?
Yes, sir. I'm
Well, they're really just waiting for you to get picked up.
I was getting my probation transferred out here anyway. I think it's just a violation.
Yeah, but even if you were transferred out here, if there's a violation, you deal with the violation from the court that puts you on
Yes, sir.
probation.
Yes.
Okay.
Yes. I was just gonna check in with the probation officer if I was able to get out.
Yeah, I'm seeing, is it Chattooga?
Yes.
Like Chattanooga, just missing a couple
Chattooga,
letters.
no, it's
Yeah, I know, just-
Georgia, not Tennessee. Yes.
Yeah, I understand, just missing a couple letters. All right, so Chattooga County, it's going to have to come pick you up. What they'll do is if they don't get you within the time they're allotted, they'll bring you back to court.
Well, I've been here 30 days waiting on them, Your Honor.
Yeah, but you had a jail sentence here, right?
No, but the time's been up. I signed my waiver on the 29th of July.
But then you had to sit for 30 days because, Mr. Wims,
Oh,
if you want me to explain it
Oh,
to
I'm
you,
sorry,
I can
I'm
do
sorry.
that. So they don't get told to come pick you up while you have a pending case here.
yes, yes,
So it wasn't until you resolved your case, which looks like July 29th
correct,
of 2025.
correct. It resolved on 29th, and I signed my waiver on the 30th
Of,
of July.
July. Well, usually give you 30 days, but what I'll do is,
Correct.
can we reach out to the jail and see if they have any, they'll try to talk to, make sure they've got the information, because, yeah, I don't want you to sit here for another 30 days and find out they
'cause-
still haven't got
Yeah,
it.
I'm not trying to over talk you, Your Honor, but I sat here, I went to misdemeanor court, they gave me time served, and that was up on the 30th. I signed my waiver, and,
I understand, but that was less than 30 days ago, which is usually the time we check up on it, so I'm having them check up on it.
oh, yes, but I had 23 days at the time I went to court.
But those don't count until you're,
Yes, sir.
you have a hold, right, from Georgia. The time for them to come pick you up doesn't start until we say we're done with your case, or you're released, otherwise say you make bond or something like that. Then they have to come get you.
I understand
So the
that.
23 days beforehand,
No, what I'm saying is I've been in jail since July the 6th.
I don't know how else to explain it to
Okay,
you, Mr. Wims.
It's been over 30. I understand.
So it's been over 30 days, but the clock for them to come get you doesn't start until your sentence here was done.
Okay. Wasn't my sentence done on the 30th of July?
No, because you pled to 30 days, and that was, you'd only been in for 21 at that point.
So I don't sign the waiver. I'm lost. Yeah.
I'm having them look into it for
Okay,
you,
yes,
Mr.
sir.
Wims.
Yes, sir.
I don't want you to sit any longer than you
Yes,
have
sir.
to.
Yes, sir.
But you had to serve your 30 days that you
Yes, sir.
took down here first, which didn't expire till probably earlier in August. Then they get 30 days to come pick you up before we check to make sure about that. It hasn't quite been 30 days, but I'm going to have them do that anyway.
Okay.
Since you're in front of me, I want to make sure
Thank you.
we
Your
don't say, come back in 30 days, and it turns out they should have got you before then. So I'm having them check on that while you're here.
Thank you, Your Honor.
All right, thank you, Mr. Wims. So we'll just put him on the October 29th for status at 9. Douglas Dawsey. He's here now, they said. Mr. Dawsey. That would be Mr. Maddox, but I think he's talking to someone in the back. All right, Mr. Dawsey's here, 25 CF 1590, represented by the Public Defender's Office, charged with child abuse without great bodily harm. Is there an information, Ms. Barrickman?
Yes, it was filed August 20th.
All right, do we have a copy? Can we check Mr. Williams' stack? For some reason, the docket has all different lawyers than it should be. Mr. Dawsey, was there a reason why you weren't here at 1:30?
Yes, sir. I was trying to go apply at another job, and I thought I had enough time.
Okay,
I overshot it.
I mean, you were at least 30 minutes late.
Oh, I was downstairs at 1:44.
Were you in the courtroom at 1:44?
Like, however long it takes to get from downstairs to up here, I'm not really sure.
I don't know, but it's still late. So
Yes,
just
sir.
make
I
make sure you get
apologize.
here on time. There's a warrant out for your arrest because you weren't here.
Yes, sir.
I'm going to withdraw it,
Yes, sir.
but you got to be here on time.
Yes, sir.
Judge, in Mr. Dawsey's case, we'll go ahead and enter a plea of not guilty, request trial by jury, 15 days for any pre-arraignment motions.
All right, Mr. Dawsey, you're going to come back on October 27th at 1 o'clock for your pretrial conference. Stay in touch with your lawyer. It's not going to be Mr. Russell, it's Mr. Maddox, who's currently out of the room.
And I'll give him a card, Judge.
Okay.
And it's the 25th, shouldn't it be? Not the 27th?
No, that was this week. October's 27th and 29th.
Oh, okay. My bad.
You had me for a second.
Okay, thank you, Judge.
All right, thank you, Mr. Dawsey. Be on time. October 27th at 1. All right, anybody else that was supposed to be on the 1:30 docket for arraignment? Oh, Tristan Colley. All right, and then it's set for October 27th at 9 already. So just put that on there. All right, Ms. Merrifield, did you have something quick on the? I would assume so. I just didn't see that.
Is there anyone on Zoom, Your Honor?
I can check.
This was noticed on the 6th of August, Judge.
What's the name?
It would be Ryan Jackson and 21 CF 2894.
I'm sorry, give me the number again.
Yes, sir, it's 21 CF 2894.
Oh, did we have Shemaiah Smith? Mr. Sheik, have y'all seen anything about that?
I'm aware of this. I don't know if I'm just worried that the victim wasn't properly notified.
That's what I'm asking.
So I can give the court a little bit of a backdrop. Bernie Merrifield on behalf of Ryan Jackson. So Mr. Jackson's case originated in Crestview, resolved through Veterans Treatment Court. It was originally set down in the south end. It was canceled for convenience of the listed victim. That was done with ASA Giardina. So we reset it up here to the north end. I believe Ms. Giardina provided the contact information for the listed victim and then copied Mr. Sheik on it. And then notice was filed on August the 6th.
Hold on a second. I do have a Gordon. That's who it is?
It's Miss Gordon, yes. Mr. Jackson?
Is on Zoom.
That would be the listed victim, Judge.
Okay. Let's go ahead and handle that real quick.
And Mr. Jackson is present for the record.
You are in the meeting now.
All right, Ms. Gordon, can you hear me okay?
Yes.
And I can hear you. All right, I believe you're here for the Jackson case, is that right?
Correct.
Okay. All right, so this is going to be 21 CF 2894, State of Florida versus Ryan Jackson. We're here for a petition for expungement. Ms. Merrifield is here on behalf of Mr. Jackson, who's also present, state's represented by Mr. Sheik, and the victim, Ms. Gordon, is on Zoom. All right, Ms. Merrifield.
Yeah, I apologize, Judge. I was giving some information
you're fine.
to ASA Sheik. So, Judge, we're here on Mr. Jackson's petition to expunge. It was filed on July the 17th, 2025. Mr. Jackson complied with 943-0585 subsections 1 and 2 of Florida statutes, and that his case was eligible per statute for record expungement based on having no prior criminal history. He wasn't convicted of the charge offense. He did successfully complete the Veterans Treatment Court program, and the state filed a no prosecution. For the court's awareness, he entered Veterans Treatment Court, which does require consent of the division prosecutor in contact with the listed victim. That was back on August the 12th of 2022, and then he graduated in December 16th of 2024. During the almost 2.5 years he spent in the program, he was compliant, completed all the requirements, received the certificate of eligibility from the Florida Department of Law Enforcement pursuant to 943-0585 and 3.692 Florida Rules Criminal Procedure. He received that back on June the 4th, 2025, which, as the court is well aware, that is a condition precedent to requesting the record expungement. He has satisfied all those requirements, and so he is requesting that his record be expunged. And I do have some case law, if the court would like the benefit of that now, or I can wait till after the argument portion.
You can hand it up now.
May I approach, Judge?
Yes, please.
And I have also provided that to ASA Sheik.
All right, Mr. Sheik, what's the state's position?
The state would like to allow the victim to be heard in this case, Your Honor.
Okay, Ms. Gordon, let me get you back up.
Yes.
Can you raise your right hand to be sworn? Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name, please?
Rebecca Gordon.
All right, Ms. Gordon, what would you like to tell the court regarding your concerns about the expungement?
I was moved to Florida on lies, and I just feel like he's very deceitful and lying. He completely uprooted my whole life, my daughter's life, who now suffers from PTSD from the incident and has been in therapy for several years after witnessing what he did that night. And I feel like there should be punishment on him because we have to live with the hurt. And I just don't think it's fair that he just gets to walk away, and we had to go through so much after this event.
Okay. Any questions for her, Mr. Sheik?
No questions from the state. Thank you so much.
Ms. Merrifield, any questions for her?
I only have one question.
Go ahead.
Ms. Gordon, have you spoken with Mr. Jackson since the arrest?
Absolutely not.
Thank you, ma'am. That's all I have.
All right, a couple of quick questions from me, Ms. Gordon. When he entered the Veterans Court program, did they talk to you about that?
They did not. Actually, when they called me to tell me he was trying to expunge his record, was the first time I heard that anything ever came of the case. I was never notified of anything.
So I'm just looking through the records. Okay, anything else from anybody else?
I have argument, Judge.
All right, go ahead, Ms. Merrifield.
Thank you, Judge. So in the case law that I provided, specifically Anderson v. State, which is 692 Southern 2nd 250 out of the 3rd DCA, Anderson stands for the premise that satisfaction of the requirements per the statute does create a presumption in favor of expungement. But additionally, Anderson provides that the court must rule based on the facts and circumstances of a particular case rather than just the charged offense. So for way of background, Mr. Jackson is a 100% disabled vet. He served 15 years honorably in the United States Air Force. During vet court, he completed all treatment to include the need for a hyperbaric chamber based on some specific issues. He has continued in therapy well beyond the 2.5 years. As the court is well aware, vet court for a felony is 18 months. He did complete 2.5 years. The case involved a terminated romantic relationship between Mr. Jackson and Ms. Gordon, where Mr. Jackson allowed Ms. Gordon and her daughter to remain in the home until the daughter completed the school term prior to this offense being charged. There was an injunction filed based on the arrest that was naturally terminated in March of 2023. There was no violation of that injunction. He has not had any contact, as Ms. Gordon testified today, with her since the arrest. Ms. Gordon doesn't live in the local area based on correspondence that we saw in the injunction case. I believe September 2022 is when I received notice that she had moved outside of the state. Mr. Jackson continues to participate in VA programs. He volunteers for VA programs for other disabled vets, entered vocational rehab, and is now currently in school. Denial of the petition would greatly impact his ability to be able to be employed and obtain employment. He's actually lost employment in the local community just based on the charged offense. So we are asking that the court grant his expungement based on him complying with the rules and the statute. I would also like to point the court to Gonzalez v. State. That's 565 Southern 2nd, 410, also out of the 3rd DCA. Gonzalez stands for whether the public would have a compelling interest in having knowledge of the events that led to a person's arrest. For example, in Gonzalez, that was a firefighter charged with possession of cocaine or purchasing cocaine. And the Gonzalez case stood for that it would be an interest, the public's interest, because that was a person placed in public trust. Mr. Jackson is not a public servant. He's never acted as a public servant and has no intention of being a public servant. So as such, I don't believe that there would exist a reason that the public should know or have access to a prior arrest. He has not been previously adjudicated, doesn't have any criminal history. He satisfied all the terms of pretrial release. He satisfied the terms of Veterans Treatment Court, satisfied the terms of the injunction, and satisfied the statute and the Florida rules. So for that, we would ask that the court grant his expungement.
Mr. Sheik, anything from you?
Your Honor, we just ask that you take the victim's statements and allow them to speak for themselves, Your Honor.
Okay. Anything else from you, Ms. Gordon?
Not that I can probably speak on, you.
All right, I just want to point out something, which is 943.0585, which is the court-ordered expunction of criminal record statute. Paragraph 6, subparagraph B states that a person who is subject to an expungement can lawfully deny or fail to acknowledge the arrest covered by the expunged record, except when the subject of the record is a candidate for employment with the criminal justice agency, is a defendant in a criminal prosecution, is concurrently or subsequently has petitions for relief under the record sealing, is a candidate for admission to the Florida Bar, is seeking to be employed or licensed by the Department of Children and Families, Division of Vocational Rehabilitation, Department of Education, AHCA, APD, basically all the state organizations and agencies that have to do with dealing with sensitive people, Department of Education or any school, even as a contractor, licensee, Division of Insurance and Agency Services, or to be appointed as a guardian. So I point that out that, even though an expungement can be granted, that a person can't deny that arrest under every single condition, including when applying to work with or even volunteer with children or other people, elderly, disabled, or anything else. So there is still some protection to certainly the community. I've read the case law, not only today was I reviewing it during the hearing, but I've read these things before. These are not new cases. I'll point out that Mr. Jackson went through the entirety of the Veterans Court program. I don't see any indication that he had any issues going through the program, such as stepping back or even being sentenced to jail for a violation. Everything was dismissed as of, I believe, January of 24. Is that right? So that means it's been over a year and a half since the case has been dismissed. I've also taken judicial notice of the injunction, which is 21 DR 3571, which I've also reviewed, showing that the injunction had expired March 1st of 2023, so almost 2.5 years ago. And from the testimony of Ms. Gordon, the victim in the case, is that there's been no contact since the arrest, despite the fact that he's been done with his case for a year and a half, and then the injunction has expired 2.5 years ago. And I understand, Ms. Gordon, your concerns, and they've been considered by the court, but I'm going to grant the petition. If you can send me an order, Ms. Mayerfield.
Judge, I do have a proposed order here, if the court would like a paper copy.
I'd rather it go through the normal system. If you could send that to my assistant, that way, we're really pushing towards everything having this digital watermark on it.
Yes, sir.
So if you could just send it to my office, and I'll have it signed as soon as I possibly can.
Get that filed today. Thank you, Judge. That's all I have this afternoon.
All right, thank you, Ms. Gordon.
Thank you, Your Honor.
Have a good day. All right, I believe we have someone that was on the 1:30 docket, and it should only take a minute. State dismissed Shemaya Smith, correct?
Correct, Your Honor.
Apparently she's on Zoom. I'll tell her that. All right, is that you, Miss Smith, as Zoom user?
Yes.
Okay. Miss Smith, I'm sorry. I'm sorry, I didn't know you were going to be on Zoom, or at least I forgot about it if I was told about it, but the state has dismissed your case.
Dismiss my case,
The state did, yes.
so I do not have to worry about it at all.
Well, you don't have to come to court and it's over.
Okay.
Whether you choose to worry about it still is up to you.
Okay.
All right.
Thank you.
Thank you, Miss Smith.
Thank you.
And I've got a Heather Holmes. Who's that for?
I'm sorry, what, Your Honor?
Heather Holmes. Does anyone? Okay, that's what I thought. All right. Ms. Basso, Mr. Switek, and Mr. Cabo, if you're coming, if y'all can come up real quick.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take 1. Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Fire. Damn thing ain't working.
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Do we need Mr. Pfizer at all? Do you want to go talk to him? Do you want me to? Okay. Well, just, do we need to bring him up at some point, or do you want to leave him up here so we can go talk to him in the back, or? I understand, but I'm trying to be nice. I don't just tell people what to do. Mostly.
Good afternoon, Your Honor. Before the court is Jason Miles, Dixie Dan Powell on his behalf. We're here on a motion for early release of a ELC program, I believe, with the program coordinator has recommended his early release. He's almost finished. I think his release date was September. Back when we filed this,
September 4th, next Thursday.
September 24th, I thought, but
No, 4th.
4th.
Yeah, next
So,
Thursday.
by the time we got everything filed and we got the state all the medical records for his father and his father's girlfriend that were dying, both dying of cancer, we were a little late, but a few days would help.
Well, you're saying September. What was filed in September?
Oh, no, that's his release date?
Oh, that's his, okay.
Yeah, I thought it was September 24th in the motion, but Jason, Mr. Miles says it's September the 4th, but we had filed it back, I believe, in late July, early August, for the motion, and then the state wanted to see the medical records based that his father was very ill, and then his father's girlfriend, long-term girlfriend, is dying of cancer at the
She
same
did
time.
die. She passed away a couple weeks
That's
ago.
what, yeah.
I'm sorry.
So we've kind of filed on a hardship. And it was the program director, Dana Claw, recommended and asked me to ask for early termination.
Has she written anything as far as what she believed about the situation and how we did in the program?
I think I put it in the motion, Your Honor. I don't have anything directly from her. But I think I reiterated what she had said, that he was exemplary in the program.
Sorry, I know I've read the motion, I just couldn't find it in the file, so I had to go look in the clerk system for it.
Sorry, sir.
All right. Anything else that you want to put on as far as evidence or argument, Mr. Powell?
No, Your Honor, I believe the state was in agreement at some point.
Well, here's what I don't understand, and this is kind of why I wanted to have the hearing, is that on November 4th of 2024, he entered a plea to 11 months, 29 days in the Okaloosa County Jail with no credit for time served. This often happens and when someone's wanting to do the ECLC program. And I think I brought it up sometime earlier this week that, how does this work when we've gained time and do they finish the program in time? And it's always been my concern is that someone's going to get out of jail before they finish when that's the whole point of what the agreement was.
Sure.
Or get, because sometimes it's the defendant, it's like Mr. Miles' situation, might want to stay in order to finish the program because I think it's that beneficial to their life.
Yeah.
So it's been kind of a concern of mine how this is supposed to work. But I guess what my concern is when someone's sentenced to jail, that there's not really such thing as early termination of jail. I mean, there may be a motion to modify sentence, but even then, at that point, you may be past that date. But my understanding from what Mr. Powell said, that you expect your end of sentence is about a week from now.
Yes,
In fact, exactly a week from now, if it's the 4th.
And he has finished the program successfully.
Okay. Has the state verified that?
I have.
Okay. And that's the other issue, is just having that information, because you did file it a while back, and I
Yes.
just wanted to know as far as an update. Without objection, I'm going to grant the motion. I would suggest if you could send me a quick order, Mr. Powell, because although it can be put in the minutes that your motion's granted, he's to be released.
Yes, sir.
I'm not always sure court minutes get the job done. So if you can send me over a quick order explaining what's been granted, I'd be happy to sign it as soon as possible to make sure there's not any other delays
Yes, sir.
for Mr. Miles. I certainly am glad he's gone through the program. Everything I've heard about the program is it's a life-changing situation. And I don't think Ms. Claw would be in a situation where she would be on your side if you hadn't done everything you were doing. Obviously, you've given us an update of unfortunate circumstances of what's happened since. The original hardship was talked about between those loved ones of yours who've since passed. But I certainly applaud your efforts to get through the program and do what's right. I just certainly like to make sure I point this out is I try to say this in a way that doesn't come off as saying going too far, but it's often easy to find the light when you're in a place like you are right now.
I completely understand that.
But what I sometimes say is don't lose it in the parking lot when you're walking out.
I completely understand.
Because I think everyone who's been through the issues that you have, mostly of your own making, right? But you fix those through the help of others, that it's very easy to slide back into that if you're not faithful to what you've learned and that you're wanting to continue living the life that you've made for yourself through this program. So make sure that you do that for yourself, first and foremost, and then do it for those who do want you around and are your loved ones. But it's a day-by-day situation, as I'm sure you've talked about many days over the past year.
Yes, sir.
So make sure that you stick to that and enjoy the fruits of your labor.
Yes, sir.
All right. Thank you, Mr. Miles.
Thank you, Honor. And these few days will help tremendously because he is only caretaker for his dad at this time. And
I understand, and part of me wants to say, it's just a week, what's the big deal?
Yeah.
But that's not the right thing. It's you finish the program at this point. You've gone through the treatment or rehabilitation that we were hoping for, and I don't see any further need to punish you with another week in jail when you've made so much progress.
Thank you, sir.
Thank
it means
you,
the world. Thank you. God bless you.
And we did, we have a unopposed order in the portal or either, but I will refile it.
Oh, wait, is that it there? It's strange. It's showing there, but it shows 0 pages, which means there's probably some issue with it getting through the portal. So if you could email it directly to my assistant,
Yes, sir.
I think I'll get to that sometime later today.
Yeah. What happened was when the clerk's office was having their, I think, portal problems or backlog, so.
I appreciate that you use the past tense, but I think we're still chin deep in that situation.
Thank you. I hope that doesn't affect the statute of limitations because I got several pending in there. See you, Dave.
Ms. Basso, did you have something you wanted to have?
Your Honor, actually, Ms. Rivers and I have one with Mr. Moore if the court would consider.
Yes, I'll take that one next. Sure.
It's Mr. Osborne's case.
Osborne. That's 2016 CF 1542.
Yes, Your Honor.
I think we talked yesterday that the suppression motion we weren't going forward on today.
That's correct, Your Honor.
Can we just ask that be reset, Your Honor? The next available, I don't know if the 25th is available, because that's already very full. It might have to be the one after that.
Well, let's see how today goes, and then we'll go from there. And if y'all want to tell court security who to line up next, I'm fine with that, as whatever order y'all decide to go in, but we got to get moving. I think everyone's been here a lot this week.
Your Honor, yes. Your Honor, Mr. Osborne is present now. This court previously had entered an order at our request asking his previous attorney to provide evidence, specifically a disc. And I had spoken to his previous attorney, Mr. Moore, at the Dairy Queen about the issue. Based on my understanding and speaking with Mr. Moore, he would willingly comply with an order. The court did enter an order. He has since filed a response asking for a hearing.
I see that was filed some time ago, but I didn't see it until just now. So I'm not sure if that just didn't get processed through or what, but I'm reading it as you're talking. Go ahead.
And Mr. Moore is present here today. He had requested a hearing to address the issue of having to produce the video. My client is more than willing to provide testimony as to the reasons why he wanted Mr. Moore to provide the video.
All right.
I believe.
I think the concern is, or the claim that I've heard previously, is that this video that you have, Ms. Rivers, is somehow different than the one that he saw when he was represented by Mr. Moore and what Mr. Moore showed him in the jail.
Correct.
So I don't understand quite why that could be, but
Regardless, I feel like as his attorney, I have to ask for that and
sure.
advocate
So
for
I'm
that.
asking you to put on whatever evidence from him that you may want to. I'm certainly not requiring that he testify, but if you want me to entertain that, I certainly will.
Yes.
All right, Mr. Osborne, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Absolutely, Your Honor.
Okay.
Your Honor, do they want to invoke the rule?
I don't think they want to, because frankly, I think it's probably important. This might be one of the only times I think a witness who might testify later should probably hear what the other witness is saying, so we know what the issue is. Go ahead. No one's invoked.
Would you please state your name for the record?
Kenneth Allen Osborne.
Mr. Osborne, are you here today asking the court to require Mr. Moore to provide certain documentation?
Yes, ma'am, I am.
Now, as I had mentioned before, Mr. Moore had previously represented you, is that correct?
That is correct. I hired Mr. Burt Moore from word of mouth because I was told that he would allow his clients to make payments. Considering I was a disabled American veteran and still am, I didn't have a whole lot of resources to draw from, so I hired Mr. Moore.
So during the course of Mr. Moore's representation, did he show you any videos and provide you with any discovery?
He showed me a video. He brought his laptop to the jail one day, and he says, "I want to show you what they found on your camera." I said, "On my camera?" And he said, "Yeah." And
Did you watch a video?
I watched the video. It started and it stopped.
Did there come a point in time where I became to represent you?
Yes, I had filed a post-conviction motion under Court Rule 3.850 and alleged ineffective assistance of counsel on several issues. And one of the main issues was the fact that Mr. Moore was appointed as appellate counsel over my objection to Honorable Judge Flowers, and he was appointed as appellate counsel, and the biggest issue was, besides things that he told me that did not come to fruition, was the fact that he did not preserve for appellate review the dispositive issues of the motion to suppress.
Now, getting back to the video, this video, did I show you a video that was allegedly coming from your camera?
Yes, ma'am, you did.
Now, what is your concern?
What I saw in the video that Mr. Moore showed me was not the same as what you showed me. I was appalled at what I saw in the video that you showed me.
So you're asking the court to have Mr. Moore produce the video that he showed you, correct?
Yes, ma'am, that is true.
And in your concerns is there's something different and something wrong?
There's something really wrong with what I saw and what you showed me.
Questions, Ms. Basso? Anything else you want to present? Anything the state wants to present?
I believe it was Mr. Moore's response.
Mr. Moore, come on up. You can go to the podium, it's fine. Podium's fine, Mr. Moore. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
All right, go ahead, Mr. Or if you could introduce yourself on the record.
Oh, I'm sorry. Yes, my name is Bert Moore. Your Honor, there was a court order entered, and in my response, I'm sorry you didn't get a chance to see it. I filed it pro se. So.
And I filed it. I've read it since.
Yes, sir. Judge, my first objection was, and I think I have to preserve that, is whether you had jurisdiction to order me here. I'm here voluntarily, so I want the court to know that.
And my issue, it was my understanding that, and maybe I've got this wrong, that you were willing to do this, you just wanted an order because you were concerned about potential issues because you didn't represent them anymore.
Your Honor, we had this discussion, and I'm sure and I say Ms. Bosa's name wrong every time, Your Honor, for the last 25 years, so I
understand why people get it wrong so often. It's Basso.
Basso. Judge, I can't do it. I'm sorry. I can't even say her first name correctly. So, anyway, she and I had a discussion one time. Mr. Osborne had requested this from me before, and we were in front of Judge Flowers. Judge Flowers did things in chambers occasionally. He advised me at that time not to turn over the video. Okay. And so, based on that, because, Judge, it is and then I got to thinking about it as I got ready for this hearing, I may be having possession of a crime, which I don't want to have in my possession either. Since I am suspended, Judge, I did call the Florida Bar to find out what my ethics obligations were, too. The video, Judge, but I do want to make sure it's clear on the record. Whatever the state gave me is what I showed him. And I do not want it to be implied in any way, shape, or form that I doctored that or conspired with the state to do something inappropriate or in that, Judge, I don't appreciate that. But I do, Judge, this is my file. I haven't looked at the video, so I don't know what it says. And this is the only video I have. And it could be all the discovery they gave me. It could be the discovery without there was a part of the phone. There was a phone video, and it was provided to me by the state. I'm not good enough to doctor anything, Judge. I wouldn't know how to anyway. And so this is what I have in my file, Judge. So if the court will tell me what to do, I will do it.
Well, I guess I don't want it to be a situation, because now that I've read your response, and I have a better understanding of what this video is at least alleged to be.
Yes.
I somewhat join your concern about what is on this video, and I'm not sure if it rises to the level of potential criminal behavior just by being in possession of that video. But turning it over, you don't want to be in a situation that if it turns out someone thinks it's a crime to be in possession of, well, now you're distributing it. So what I would,
especially in a courtroom and on TV.
Well, everyone's gonna, yeah. So what I would suggest, and I'll certainly take either argument or objection to it, is to have Ms. Rivers and/or Ms. Basso review what you have to make sure it's the same thing that's been turned over to Ms. Rivers at this point.
Because Judge, I would prefer, frankly, to give it to the state.
Sure. And then even in your possession, Ms. Basso, if you want to show it then to Ms. Rivers, I would suggest doing that without some sort of, we'll do it next week type issue, because then there's going to be potentially the claim of, some sort of chain of custody from Mr. Moore to you, and then Because I'm not sure what's really being claimed, other than I thought it was just, well, that's not the same video I saw, but now there's kind of implication or an accusation that someone may have tampered with a video.
That's my understanding, Judge, and I'm very concerned about that.
Okay. So I don't want it to be a situation where, well, someone may claim that Mr. Moore gave the video to Ms. Basso and suddenly it changed again or something like that in the meantime. So the problem is we don't have a whole lot of, most people don't carry around a disc player anymore. So. Okay. Wow. We'll take it out of the museum. And then if y'all want to review it to see if you claim it's something different, but I don't want this to be a situation of, based on what I've heard it shows, that it be repeatedly shown to anybody, including the defendant, once he knows that it's accurate as to what's been turned over since. I just don't understand, short of some technical glitch, how it could be any different. And frankly, from what I heard just now from Mr. Osborne, I don't know what's even allegedly different other than there was something wrong. So I don't even know what that means at this point.
Your Honor.
Hold on. You haven't been asked a question, Mr. Osborne, and I gave the lawyers a chance to ask you questions about it, and the only thing I heard was there was something wrong with it. And frankly, I'm not sure what that means. You're free to talk to your lawyer about it, but there wasn't anything definitively said on the record as to what was different.
Your Honor, I believe if the court will allow, and I ask him, he will tell you specifically what his concerns were.
Okay, well, I don't like the idea of listening to new testimony after everyone's kind of stopped providing evidence. But also, I'm understanding that, this is a 2016 case, it's already come back, and I'd like to make sure it doesn't come back again. So what is your concern, Mr. Osborne?
Thank you, Your Honor, for your time.
That's my job, Mr. Osborne, just please answer the question.
Mr. Moore alleged that I requested the video of the incident. That is not true. I requested only the search warrant photographs that were on a disc and also the body camera videos of the search of my property. And that is evidenced by the writ of mandamus that I was forced to file because Mr. Moore refused to hand over my file after many, many requests. And I have letters that I can bring forward if necessary asking for those, asking for my case file.
I'm still trying to get where we're talking about the video, Mr. Osborne.
What specifically was different from the video I showed you and the video Mr. Moore showed you? What specifically was different?
Okay, what was specifically different was the video that I saw did not have any images up underneath any girl's skirt. And one of the dog attacks was not in the video that Miss Moore showed me. And the brother's arm, excuse me, the brother's arm extended toward his sister is not in that video.
I'm not interjecting, but I certainly still have some concerns.
And do I need to, I'm really very concerned that he's made an inappropriate statement that's not.
Well, at this point, I'm just not sure even which video we're talking about has one thing or another.
And Judge, I was confused about his testimony.
I mean, Ms. Rivers, I don't want to keep saying what I think and then, give him a second, third, and fourth chance to tell me what was different. I need to know what his testimony is, and then that's going to be the end of it, and then I'm going to make a ruling on what needs to be done.
Mr. Osborne.
Yes, ma'am.
What type of video did Mr. Moore show you that you have concerns with?
He showed me a video of the alleged incident.
Of what?
Of the video that was captured on my camera whenever I took a dog that I thought belonged to this family to their home.
The only thing different was the things you just mentioned.
Yes, ma'am. the video started. And Mr. Moore told me if there was anything of a sexual nature on this video, that he was not permitted by law to show it to me.
Did Mr. Moore show you the video?
Yes, he did.
All right, what did the video consist of?
It consisted of watching a little puppy get attacked twice, and I yanked the dog out of the vehicle twice.
Talk about what the video, not what you did, what was shown on the video.
It showed that on the video. It showed the boy extending his arm to his sister. There was nothing inappropriate as far as I'm concerned, other than the fact that whenever the girl jumped up in my vehicle,
Again, what you saw on the video.
it shows me tapping her on the knee and telling her she cannot get in my vehicle.
Now, did I show you a similar video?
The one that you showed me was similar.
Okay, what was different?
There was no images of anything up underneath this girl's skirt in the video that Mr. Moore showed me. However, the one that you showed me had several images of that.
You are concerned because of the differences.
I'm concerned because of the differences than what I saw that he showed me and what I saw that you showed me.
Any other questions for Mr. Osborne? Ms. Basso, any questions for him? All right, does anyone have any other questions for Mr. Moore?
Your Honor, I just want to, can I say, I'm.
Go ahead, Mr. Moore.
Judge, I just want to, can I read paragraph 4 to you of my motion, or my response?
I can read it myself. But
Yes,
go
sir,
ahead.
please.
You can go ahead and read it, Mr. Moore.
The video depicts Mr. Osborne taking a puppy in the front seat of his truck to the victim's residence and videoing that encounter, including an upskirt of the minor's female child's dress. Mr. Osborne reacted audibly upon seeing the upskirt portion of the video when he viewed the video with Burt Moore at the Okaloosa County Jail. Your Honor, I'm under oath. That is a true statement.
Any questions for Mr. Moore? Thank you, Mr. Moore. You can take your seat or you're free to go. Well,
I'd like to go, Judge. I know where the garbage can is and I know where burn pile is.
well, I understand, but I don't understand what the situation. Mr. Moore has testified that it has the same things that Ms. Rivers' video shows. If anything, Ms. Rivers has more, no pun intended.
That's correct, Your Honor.
Than Mr. Moore had. So I don't see what the issue is here.
Your Honor, he's making the allegation that something has been changed or altered, that it was not the same.
From what I've heard today and read in Mr. Moore's response and heard him say, is it was the same description of video that was provided to Ms. Rivers, which she then
Yes, that
showed
was
to
not there.
her client. If y'all want to go review the video together, Ms. Rivers, and compare it, and compare it to what you have already, and tell me if there's any differences while I handle some other cases. But if, Mr. Moore, if you don't have any issues with it further, you could give the disc to Ms. Basso from the
I'll be
state
glad to
attorney's
do that,
office,
Your Honor.
and it'll be clear on the record that you no longer have possession of said video.
Your Honor, the only concern I had up front is I did pay $150 for somebody to help me find this, and I think Mr. Osborne should be back charged for that.
I'm not sure how I do that, Mr.
Well, and Judge, I don't either, so.
But, I mean,
And that's why I would have said up front to the court, I want to be recompensed for it.
yeah, and I think I saw that in the response as well.
Yes, sir.
But
And I will give this to Ms.
Basso.
Basso.
Step out. Mr. Osborne, they're going to put you in the back while that happens, and then we'll come back if it needs to be addressed further.
Do I need to?
You do not, Mr. Moore.
Thank you.
Thank you, sir.
And didn't show me that portion.
All right, who do we have next? Mr. Gaston.
Thank you, Your Honor.
Thank you. Keep him for now so they can go look at that and see what they're.
Our approaching now is Mr. Irvin Gaston in 25 CF 1428 recalled for a plea. Just need to get his, or actually, no, I have his signature. We've reached a resolution in the matter from the approach, Your Honor.
Yes, sir. This is the petty theft, right?
Yes, Your Honor. Just plead the petty theft.
All right. Mr. Gaston, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Can you state your name and date of birth, please?
Irving Kareem Gaston, August 7th, 1984.
All right, and Mr. Gaston, you're here in 25 CF 1428, where you're currently charged with pawn fraud, which is a third-degree felony, punishment up to 5 years in state prison, and petty theft, which is a first-degree misdemeanor, punishment by up to a year in jail. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that calls for you to plead to count 2, that misdemeanor. As charged, there'll be 11 months, 29 days of probation, adjudication of guilt, 24 hours of community service, reserve on restitution for a period of 90 days, no trespass at Cash America Pawn here in Crestview, waive cost of supervision, $270 in court costs, and $100 cost of defense. In return for that plea, the state would dismiss the felony pawn fraud. Is that your understanding of the agreement?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Did you go over this form with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes.
Am I missing this thing? No.
Couldn't be.
It was just turned over.
Okay, good.
Wasn't normally where it is. All right. And are you satisfied with your attorney's advice and representation?
Yes, sir.
All right. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressure, or threatened you to enter this plea?
No.
Has anyone promised you anything in return for your plea?
No.
By entering the plea, do you understand there won't be a trial of any kind, and you're giving up your trial rights, which are on page 2 of that agreement you signed?
Yes, I understand.
And do you understand you're waiving all potential defenses that you have to that petty theft charge?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, and what is your plea to the count 2 first-degree misdemeanor petty theft?
No contest.
I'm going to accept your no contest plea as freely, voluntarily, knowingly given. On that petty theft, I'm going to adjudicate you guilty, sentence you to 11 months, 29 days of probation, 24 hours of community service, reserve on restitution for a period of 90 days. Do not return back to Cash America Pawn in Crestview. I'm going to waive costs of supervision due to the fact that you're indigent and represented by the Public Defender's Office, $270 in court costs, $100 cost of defense. State have an announcement as to count 1.
State will null cross count 1, Your Honor.
All right. Count 1 is dismissed. All right, I'm going to have you talk to probation there behind you, Mr. Gaston, because you're going to be supervised once you're released. I need you to be fingerprinted after that, and then you have 30 days to appeal the judgment and sentence of the court. All right, thank you.
All right, thank you, Your Honor. That's all I have.
All right, thank you. Mr. Russell.
Judge, I have a couple out of custody I want to call. Teresa Edwards.
Okay.
Miss Edwards is in the wheelchair. She's approaching. Case number for the record is 24 CF 2116. To remind the court, she was found incompetent to proceed and unrestorable back on July 24th. At that time, I think it was at the same hearing, no, it was at the 8-7 hearing. On the August 7th hearing, the state actually dismissed the VOP affidavit and basically put her back on probation. I believe the reason the court set the status hearing for today was for us to decide if we were going to do anything retroactive back to the original plea. After researching the issue and checking on a few things, Judge, the defense is not going to do anything about that.
Okay, so at this point, the case just goes back into, she's being supervised by probation?
Right.
And for how long is that?
It's till November of 26. And I believe Ms. Galagli was here in court last time and raised the issue with the court that they can't really supervise somebody that's incompetent and unrestorable because they can't really violate them either. So I'll let her address that if you want to hear from her again.
Come on up.
Your Honor, if I may, the suggestion that I made last time was...
If you can introduce yourself for the record.
Oh, I'm sorry. Erin Galogli, State Probation. If I may, the recommendation that I made last time was that we would send a letter to the court and an order basically saying that we're not responsible for supervising her until A, she regains competency, or B, she terminates probation, because we're unable to supervise her, she's incompetent, she's not going to be able to participate in probation, being incompetent.
Okay.
So.
State have a
if the court
position?
is-
No, Your Honor, it's the first time I encountered this kind of issue and I don't have an answer.
All right, Mr. Russell, are you asking for her probation to be terminated?
That would be ideal, Judge, because, I mean, if she's incompetent, she's unrestorable, she's not going to get any better.
The state have an objection to that request?
No, Judge.
Probation's terminated as of
Thank you,
today.
Honor.
Thank you all.
Okay. You hear that? Probation's terminated, your case is over. Just for the record, Judge, I think at one of the prior hearings, you set a status date for January 29th because we thought we were going to do the 6-month review.
It'll be canceled as the case is now resolved.
Okay, so you're done, okay?
All right.
Okay, and then my other out-of-custody judge is going to be William Ewing. Mr. Ewing is present and approaching. Case number is 24 CF 569. On Mr. Ewing's case, the reason it's here for status is, if the court will recall, we had one comp eval that said he was incompetent, a second comp eval that said he was competent, and now we've got a third eval pending. His appointment with that doctor is next week.
Yes, sir.
And so if we could pass it to September 25th at 9, maybe we'll have a report by then.
All right, any objections from the state?
No objections from the
All right,
state.
Or if you
September-
want to set another date, because
No.
I'm not familiar with this particular doctor. I'm not sure if she is quick or slow or
What was the name again?
Salinas.
I think from everything, because she, I think it's Julie, I think it's
Right.
he. It's out of Pensacola, right?
Yes, sir.
Yeah, and I've never heard any concerns.
Okay.
In fact, it's one of the reasons why I picked Dr. Salinas was because we've had, at least I personally have had, when I was in the juvenile division, some issues with some of the Central to South Florida people who were doing them remotely, that sometimes I wasn't getting them for months. So I think it should be good.
Okay.
If it's next week, let's put it on the September 25th, since the evaluation is next week at 9 o'clock, and hopefully everything will be ready to go at that point.
September 25th.
Obviously, if y'all don't have it, in order to avoid Mr. Ewing coming in again to find out we still don't have it, you can certainly file a motion to continue at that point if needed, Mr. Russell, and I'll entertain it. All right. Anybody else that y'all have in?
Judge, I have cases. I don't have anybody who's not in custody, but I
Okay.
have cases.
All right, the people I see in out of custody is Mr. Williams, but that's Miss Rivers' case, right? And-
Yes, sir.
And
Sir.
I'm not sure the ladies in the back row, are y'all have a case, or y'all with him, or?
She's here pro se for early
Okay. Who represents, does someone represent her or no? Okay. Can we handle that really quickly, Mr.
Yes,
Williams?
absolutely.
And if we can get Mr. Williams' inmates lined up. He said Durham.
May I approach with Mr.?
Sure. Oh, sure.
Backroom Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m. serving lunch from 11 to 2. We hope to see you soon.
Yes, you can go stand at the podium. All right, so this is it Talia?
Yes, sir.
Durham? 24 CF 594, 24 CF 1096, 24 CF 1108. The situation in here, Ms. Durham has asked for a motion for early termination. At my request, I set a notice of hearing to have it put onto the docket so it could be heard, which courts set things for hearing all the time. The concern's been made up that the certificate of service, which is signed by my assistant, certifying solely that copies were sent to those particular people, and it looks like it was not sent to the state. So, if you'd like to reset it for another date where you've been properly noticed, Ms. Leone, you certainly can. Otherwise, if you have a concern about the potential bias of the court, you can file a written motion as required by the statute and the rule. How would you like to proceed?
We can go ahead. I don't need another hearing.
All right, Ms. Durham, tell us why you would like to get off probation early.
Okay, I have an 8-month-old son, and it's difficult to juggle the ankle monitor box and all the all the things that when I go places, it's hard to juggle both of them at the same time.
Okay.
And I have medical concerns that I have to see specialists out of counties like Walton County or Escambia concerning my medical needs. And all my family that are very supportive are out of county too. And as far as like childcare or them helping me with my child, it's very difficult because the ankle monitor limits things for me. I have restrictions for it.
So, number one, does probation have any idea on if she's finished her conditions? State want to be heard?
No objection, Your Honor.
Okay. And from my reading of it, Ms. Durham, you were given 2 years of drug offender probation with the GPS monitor as of May 30th of 2024. So at this point, you've done approximately just under 2/3 of your probation. You're about a month short of 2/3, but certainly over half. Sounds like you've done everything you're supposed to do, and in fact have paid ahead on your costs. And hearing no objection from probation and no objection expressed by the state, I'm going to go ahead and grant your motion for early termination.
Okay, thank you.
All right, thank you, Ms. Durham. Yes.
Myself and Ms. Rivers did have an opportunity.
Can you get on the microphone? I'm sorry.
I was just going to come that way. Myself and Ms. Rivers did have an opportunity to review the video that Mr. Moore handed me here in court. We went directly into the anteroom and viewed it together, so there's no question that there was anything that may have occurred in the meantime. And I believe Ms. Rivers stated that it was the same as what she saw, but I'll let her speak to that.
Hey, Ms. Rivers.
That's correct, Your Honor.
All right, do you want to go explain that to Mr. Osborne? Do you want me to bring him up? I know Mr. Williams has some cases, and you have some cases still.
I believe it'd probably be best if we did bring him out to have it
Okay.
on the record.
And what I meant by you going to tell him is telling him and then bringing him in so he knows what that is. If you wanted to have a privileged, confidential conversation with him first. I don't think I made that clear, but that's what I intended by that.
Okay. We can do that, Your Honor, if y'all could put him in the interview room, please.
All right, and then Mr. Williams, if we could start taking your inmates.
Yes, Your Honor. How about Ms. McSweeney?
Then LaBouffe is fine. Sorry, Judge, I'm wading through
the various score sheets. All right. And would you pronounce your name for the record?
LeBeau.
Mr. LeBeau, this is the plea agreement that I went over with you back in lockup. We did do it in such a way that you'd be able to keep your withheld. If this is what you want to do, let me get your signature on it. Um, 28th, 8/28/25. Sorry, nobody ever asked me that. I always wind up dating it for them. Thank you. Whoops.
Thank you, Mr. Williams. All right, so the two things. This would maintain the withhold, correct?
Yes, sir.
Yes, Your Honor.
All right, and do we know how much probation he has left? I want to try to figure out, because it says reinstate with an additional 6 months of community control, and then followed by the remainder of his probation.
LeBeau.
LABAUVE.
Yeah, this
First
is the
name.
one that you indicated, I think, sometime in 26. It's the one we were discussing whether to modify or reinstate. Yes, ma'am.
This morning.
Your Honor, I have him terminated 5/6 of 26.
5/6 of 26. So what is the intention here? Is it going to be basically adding 6 months and then, or is it the next 6 months will be CC and then remainder is probation?
Yes, the next 6 months, and then he'll
Okay.
continue the remainder of the probation.
Because what I was starting off is just the word additional. I wanted to make sure what
Yes,
the
sir.
intent of the parties was, and we knew what those dates were. All right, perfect. So if you don't mind, Mr. Williams, I'm just going to cross off additional and say reinstate with the next
Yes, sir.
6 months on community control, followed by the remainder of his probation. So it won't extend your end date. It'll just make those 6 months a little more supervised. Understand that, Mr. LeBeau?
Sir.
Okay, can you raise your right hand? Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. Can you state your full name and date of birth, please?
Corey Sean LeBeau, May 2nd, 1998.
All right, Mr. LeBeau, you're here on 24 CF 2341 on 2 counts of, well, it's a VOP with 2 underlying counts of introduction of contraband, which were third-degree felonies. I have a plea and sentencing agreement that would call for you to admit your violation of probation, and you'd reinstate your probation with the next 6 months of your current probation term would be on community control, and then it would be followed by regular probation up until that date in May of 26 when you're to be terminated from your probation, correct?
Yes, sir.
That's what you want to do today? All right, and there's also a $100 cost of prosecution and $150 in PD fees and maintaining your withhold, correct?
Yes, sir.
All right, did you go over this agreement with your lawyer?
Yes, Your Honor.
Did you understand and sign it?
Yes, Your Honor.
And are you satisfied with your lawyer's advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand if you enter an admission to your violation of probation, there won't be a further hearing where the state would have to prove that you violated?
Yes, I understand.
And do you understand you're waiving all potential defenses? You understand that if you're not a U.S. citizen, this could lead to your deportation? And what is your plea to the violation of probation? Are you admitting or denying?
Admitting.
All right, I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to continue to maintain the withhold as agreed upon by the parties, reinstate you to probation with the next 6 months on community control, followed by the remainder of your probation until May of '26. $100 cost of prosecution, $150 PD fees. And this is a guideline sentence. I believe it's basically a modification, right?
Yes, sir.
Okay, so we don't really need a score sheet, but you didn't score anyway, so. All right, go talk to probation so they can instruct you about how to report once you're released from the jail. And then you have 30 days to appeal the judgment and sentence of the court. Thank you. Good luck, sir.
Good luck.
Your Honor, just for the court's information, it looks like he has an outstanding case.
He does.
That's the basis of the new, or the violation, so.
Right,
He's not getting out for a while.
Okay.
Just throwing him out there, because it looks like the allegations are pretty.
Right, I've already been in contact with his PD over there. His PD's been wondering when to get him back in for his judge trial. There was a judge trial scheduled. Unfortunately, we still had him over here, so in order to get a hold on him, bring him back over.
A judge trial on a new offense?
Yes, sir.
It's a pretty significant.
I'm just worried the judge trial is just the unusual part, I guess.
Yes, sir. He's represented by Grover Robinson over in either Scambia or Santa Rosa.
Okay. All right, well, obviously if they've got a hold for you, that's going to have to be taken care of, but make sure you report as you're instructed. All right, thank you, sir. Oh, after this, if we could take about a 5-minute recess as requested.
Yes, sir. All right, let me get your signature right there.
We'll take 2 minutes while you run there, but then I'm
Okay. Do you mind if I date that for you, ma'am?
Nothing else on this WIMS thing? Nothing else on WIMS?
But it's Lisa Rivers, she has to argue with the judge.
Yes. Can I explain?
All right, are these both new law violations? There's no VOP?
One's a VOP, Judge.
Which one's the VOP? The
24
case, I'm assuming?
Yeah, 24-2102 is the VOP. The other one is a new law violation that was set for arraignment today. So instead of entering a plea of not guilty, we'll be entering a plea of no contest.
So it's 11 months, 29 days jail, credit for time served, concurrent, but?
Yes, sir.
All right. All right, Ms. McSweeney, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your name and date of birth, please?
Caitlin McSweeney, 31388.
And Ms. McSweeney, you're here for a VOP on 24 CF 2102 and on 25 CF 1407, where you're charged with possession of a controlled substance. Do you understand that? All right, I have a plea and sentencing agreement that would call for you to admit your violation and plead no contest to the new law violation. In return, you'd be adjudicated guilty on all counts in both cases, 11 months, 29 days in the county jail with credit for time served. That jail will be concurrent between both of those cases. Just understand you may have more credit in one than the other, so you get credit and it's concurrent, but they're not necessarily what we call coterminous. Okay. You may have more credit in the older case. You revoke and terminate your probation, $615 court costs in the new case, $150 PD fee, and $100 in PD fee in both cases, and a $50 application, and the $100 cost of prosecution. Is that what you want to do today? Did you go over this form with your lawyer? Did you understand and sign it? Are you satisfied with your lawyer's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you into this plea? Has anyone promised you anything in return for the plea? Do you understand there won't be a trial or hearing of any kind, and you're waiving all potential defenses that you may have? In the new case, do you understand that you're waiving your trial rights, which are on page 2 of the agreement that you signed?
Yes.
And do you understand that if you're not a U.S. citizen, you could be deported because of this? As to the violation of probation in 24 CF 2102, what is your plea? Are you admitting or denying?
Admit.
Admitting.
Okay, and in 25 CF 1407, what is your plea to the third-degree felony of possession of a controlled substance? All right, I'm going to accept your admission, and your plea of no contest is freely, voluntarily, knowingly given. Adjudication of guilt, 11 on all counts, all charges, 11 months, 29 days, county jail, credit for time served, run concurrent, revoke and terminate your probation, $100 cost of prosecution, the VOP, $100 PD fee in the violation of probation case, $615 in court costs in the new 25-1407 case, as well as $150 PD fee in that case. I'm going to give you 90 days from your release date to either pay your costs in monetary conditions, otherwise, or you can also set up a payment plan for them during that 90 days, otherwise they'll be sent to a judgment. Do you understand that? I think I said it before, but it bears repeating. Revoke and terminate probation. All right, this is a guideline sentence. Well, actually, it's not.
It is a downward departure, Your Honor.
Okay, it's a downward departure based on?
Uncoerced plea, Your Honor.
Uncoerced plea. And he scored 46.6 points, which would have been 13.95 months, so it's not a huge difference, but it is still considered a downward departure. All right, ma'am, I do need you to be fingerprinted on the new case, and then you have 30 days to appeal a judgment and sentence.
Thank you, Judge. Good luck, ma'am.
All right, we're going to take a quick 5-minute comfort break.
Yes, sir.
Outstanding, Mr. Williams.
I have a.
No, we don't.
You still gonna do that thing with your Byron Williams?
Yeah, just have to get their testimony on the record.
No, Byron Williams. He wants to get his testimony. I didn't understand.
Yeah, the motion.
Charlie has to do it?
No, just talking to Charlie, and Charlie said I should go ahead and do testimony, make it clean.
I didn't understand. I got it.
Him too. He's still going on, right?
Did you tell him he was in court today, but we just kind of
Nobody bothered to tell me what's on
When I
he
came
wasn't.
for pre-trial, I saw him outside with the dog. But then something happened, I missed what happened with him.
Yeah, we didn't bother to tell him that. You know, it's like, not my job, man. You hate me. It's personal with him. He hates me, and I don't know why.
I just felt bad for the dog.
Yeah, we all feel bad for the dog.
Him and paycheck.
It's like, it's nothing personal with me, trust me.
it's like, I have plenty of them, there's no, fight over a certain word.
They all think that way, you know, prosecutor hates me. I don't even know you.
Yeah, I generally hate what they do. So it's not.
It's a case.
Recognize.
Oh, don't. Contagious. It's contagious.
It was that close. We were that close to getting out the door. Grab him next.
Has Jay done his hearing yet? Most likely.
He's going last.
No.
He's going last.
I'm done, I'm just waiting for your thing.
And about somebody who was held in, who have been released after they've been found incompetent?
Motion saying charges need to be dismissed.
I don't know which one. He'll tell you.
It's got this with Josh, this McSweeney, but I think they did it, they handled it.
Yeah, we just did that one, didn't we?
Yeah, that one just.
What hearing do you have?
Ison.
That's him.
Yeah.
And that's before kids. I'm.
No, that Ross, all these viewers are an hour and a half.
The video was.
And then the ultimate thing is. That's where you sue, like, you can get a lawsuit.
You are?
Yeah.
It's not child porn.
Yeah, I'm seeing a lot of the stuff with the.
Oh, then don't leave. If you don't have my stuff, no. I'll stick around if you.
No.
You don't have any other cases?
No. Well,
This isn't what you're thinking.
I had, the Lisa's case is not really my thing.
I don't, do you remember?
It's a motion she filed for getting off of the case. I really don't think I got anything else.
I also agree.
I'm gonna go. Let's just switch.
You know what happened?
No.
Oh,
That
that was all shit, so the.
You guys have here at least 3 years.
Yeah, but it's not gonna be.
I'm not leaving my lap.
And it's
Yeah. They're gonna get a copy now and continue.
Okay.
That's it.
Back around to the courtroom.
on the payroll, take to satisfy.
I think quite a few attorneys are.
The attorney's office.
We're just gonna stand here and look. This is a strong.
Did you tell Josh?
Yeah.
Okay, then let's
That prevented him from using the fifth amendment.
all right.
All right, you can be seated.
Cover also for me.
Yep.
Off of a case.
All right, what do we want to take next?
Max Moss, I think, because Ison may be an actual hearing.
Well, let's do Osborne real quick, because I think that should be relatively quick, sorry. I assume y'all talk about this outside of my presence.
We actually spoke about it and spoke with our bailiff, who was being very
Loop in
kind.
Mr. Williams next time.
Just had to run him over.
I lived this far.
I'm here to serve, I'm not sure if I live to serve.
Your Honor, I did speak with my client, Mr. Osborne. He did wish to make a response.
All right, so let me just make sure we're clear on the record. This is Kenneth Osborne. And it's State of Florida versus Kenneth Osborne, 2016 CF 1542. Go ahead, Mr. Osborne.
Thank you, Your Honor. I brought with me today a copy of the initial brief on appeal that Mr. Moore filed. And the portion that I'm reading from is a statement of facts. After some discussion, it was determined that the puppy did not belong to the children. During that time, Osborne touched a minor female on her leg. The young girl...
You understand this is not evidence, right, Mr. Moore, or Mr. Osborne?
The young girl told law enforcement that Osborne used a silver camera to take pictures of her. There's nothing in any of this brief that mentions anything of any images up underneath this girl's dress.
Okay. I know this may come as a shock to some people, but when attorneys write briefs, they don't always include the facts that don't sound good for their clients.
Okay, I would understand that.
But the evidence that I heard today in court, sworn, from Mr. Moore and from you, and now that I've heard from both Ms. Basso and Ms. Rivers, that the two videos, the one that was in Mr. Moore's file and the one that was turned over and Ms. Rivers had, were identical, I don't understand what the issue is. So,
The issue was, I didn't see any images of what Mr. Moore showed me. He must have keyed the video somehow and only showed me a portion of the video.
okay, so you're complaining about what Mr. Moore did in the past?
Well, it would appear something is, the images that I
You're
saw.
seeing more now than you claim you saw with Mr. Moore in the past, right?
Yes,
All right, so what is the prejudice to you now? The case has already come back on a 3850, right?
yes, sir.
So what prejudice are you talking about how you may have only seen a portion of the video in the past, but now you've seen it all?
Well, I haven't seen it, well, I was just concerned that what I saw before was not what Ms. Rivers showed me.
Okay.
But if the court is satisfied that the video is the same, I just wasn't showed that portion, and that was my concern, that something had been changed on the video.
Okay, well, you're free to talk to Ms. Rivers, but the two videos that they watched, the one that came directly out of Mr. Moore's file on a disc, they say is the exact same thing that you've
Okay.
already seen from Ms. Rivers.
But then I accept that
All right.
as fact.
Thank you, Mr. Osborne.
Oh, thank you, sir.
I'll let y'all go ahead and coordinate your suppression motion, but I think we got to get through the rest of these cases. Just reach out to Katie if you need to. I just don't know how long y'all might need for the suppression issue.
We'll do that. We should reach out to her by tomorrow and get it set. Is that
Okay.
Thank you.
For the
Yeah, no
suppression
problem.
motion. Tomorrow, we're going to find out
Oh,
what day.
he doesn't have another court date, so let's put him on the October 29th at 9 o'clock for purposes of pretrial. Obviously, I want to set another date beforehand on this motion to suppress. I'm fine with that, but it just needs to be coordinated when we've got a little bit more time, including tomorrow.
Thank you, Your Honor.
By we, I mean y'all.
Thank you.
Yes, if you're done, you're free to go.
Thank you.
Oh, Ms. Leone, the clerk has a question. On guests with Ms. Merrifield?
I wasn't aware at all about that case.
I don't even see it on my computer docket now. I remember seeing the name, but if they want a bond hearing, they'll reschedule.
Okay. Or I'll contact Ms. Merrifield and figure it out.
Thank you.
All right, Mr. Moss. Here you go, sir. Oh, you got caught? Okay. Up here. And I'll go ahead and date this for you.
All right, thank you. All right, Mr. Moss, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your name and date of birth, please?
Max Ryan Moss, 2/6/1986.
All right, Mr. Moss, you're here in 2025 CF 995, which is a violation of probation, as well as 25 CF 1282, which is a new charge of possession of a controlled substance, that being methamphetamine, which is a third-degree felony and punishable up to 5 years in state prison. Do you understand that? Do you understand that?
Yes.
I need an out loud answer. All right, I've been handed a plea and sentencing agreement that calls for you to enter an admission to the VOP, as well as a plea of no contest to the new charge of possession. In return, it'd be an adjudication of guilt, 11 months, 29 days in county jail with credit for time served. In the new case, $615 in court costs and $150 PD fee. In the probation case, it'd also be a $100 cost of prosecution, revoke and terminate your probation, and the jail time would be concurrent between those two cases. Is that the deal that you understand it to be?
Yes.
And did you go over this plea and sentencing agreement with your lawyer?
Yes.
Did you understand and sign it?
Yes.
And are you satisfied with your lawyer's advice and representation?
Yes.
This is apparently a downward departure, is that right?
Correct.
Yes, Your Honor, based on the uncoerced plea.
All right, where you scored 17.55 months in prison, but you're being given a year in jail. You understand that?
Yes, sir.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Are you I'm sorry, has anyone forced, pressure, or threatened you in any way to enter a plea?
No.
Has anyone promised you anything in return for your plea?
No.
Do you understand if you enter admission to the VOP, there won't be an evidentiary hearing where the state would have to prove that you violated your probation?
Yes.
Do you understand that by entering a plea of no contest to the possession of the methamphetamine, that there won't be a trial of any kind, and you give up your trial rights, which are in the agreement you signed?
Yes.
Do you understand that you're waiving all potential defenses?
Yes.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes.
And you understand this is an adjudication of guilt, so all of these are convictions, including the 2 felonies?
Yes.
All right, and as to the violation of probation in 25 CF 995, do you admit or deny your violation?
Admit.
And in the 25 CF 1282, possession of a controlled substance, that being methamphetamine, do you plead guilty, no contest, or not guilty?
No contest.
I'll accept your no contest plea as well as your admission to the violation of probation as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty on all counts of both cases. Sentence you to 11 months, 29 days in county jail with credit for time served. That'll be concurrent between both cases, all counts. In the new case, $615 in court costs and $150 PD fee. In the VOP, it'll be a $100 cost of prosecution. Your probation will be revoked and terminated. You'll have 90 days from the date that you're released from jail to either pay your costs and monetary obligations, set up a payment plan, or they'll be sent to judgment. Do you understand all that, Mr. Moss?
Yes.
This is a downward departure based on an uncoerced plea bargain between you and the state. Otherwise, you would have had 17 and a half months in prison. Do you understand that, Mr.
Yes.
Moss? All right. Do you have any questions for the court?
No.
All right. You didn't make it very long on probation. I suggest when you finish your jail sentence, you try to do things a little bit differently, Mr. Moss. Also, do you understand that you may have a different amount of credit between the 2 cases because the one's a little bit older, and so you'll be released once you've gotten to that 1129 with credit on both cases?
All right.
Okay. Thank you. You need to be fingerprinted, and then you're 30 days to appeal the judgment and sentence.
Thanks, Judge.
Next case.
Judge, I have Jonathan Eisen. This gentleman was in for a competency hearing back end of May 29th. The court set him off for today. He was coming up on 5 years of continued incompetency. And Dr. Zeman, he'd been released from Florida State Hospital. He'd appeared to me to have decompensated in the brief period of time. I had Dr. Zeman evaluated. Dr. Zeman said that he was incompetent and unrestorable.
Okay.
With that, the court passed the case until today. The court had inquired of Mr. Eisen things like where he was going to be living and stuff like that. And did not get very good answers from him. Very clear and concise answer.
And from what I remember, my issue was not an issue about getting him back to court. My issue was about his own safety and welfare.
Yes, sir. Unfortunately, I reviewed some case law and statutory law. I filed a motion for release. But I think what we're actually here for today is I think we've reached that 5-year point, and so it's time for the court to dismiss without prejudice to refile should he ever become competent.
All right, state have any objection to that?
No objections, and I have spoken with the victim to make sure that they were aware that this could be a possibility, and they're fine.
Okay, as required by Florida statute, now that he's got to the point of 5 years of continuous incompetence to proceed, this court's going to dismiss his case without prejudice to refile should he become competent again, but from all the reports that we've read, is that he's not restorable.
Thank you, Judge.
Thank you, Your Honor.
All right, sir, your case is over with. You should be released unless you've got other matters pending.
No, sir, sir, don't.
Okay. And Judge, if I can be excused.
If you're all done, sure, Mr. Williams, thank you.
Yeah, if there's somebody else back there for me, I'm not aware of.
Okay. Well, I think it's a different Mr. Williams. But who do you have, Miss Rivers?
Your Honor, we've reached an agreement in this matter. She's just going to need to sign the document. Did you have any questions?
Ms. Galugli? Officer Galugli, do you have that paper that you were showing me? Oh, you gave it over.
I staffed it with both of them and gave it to him.
Well, Mr. Maddox is not here, but Mr. Russell, have you taken a look at it?
I'll let him know, Judge. I don't know what the deal was, but if that's what they're saying is the deal, I don't have no reason to doubt it.
Y'all verified it was supposed to be 1129 jail.
Yes, I remember that was a downward departure that we did for that case.
Your Honor, we've reached an agreement in this matter.
I wanted to go pick them up. All right. All right, it says on counts 2, 3, and 4, and there's nothing else. What are we doing with counts 2, 3, and 4?
Trying to remember, is this the one, I think I only signed, I think the information only has 4 counts, Your Honor.
Count 1 was the felony possession of a controlled substance, 2 years probation, substance abuse evaluation, counseling, or comply with ECLC, costs, and then it says on counts 2, 3, 4, and there's...
Oh, that was, yeah, credit for time served. I apologize, Your Honor. Misunderstood the question.
I just needed 3 letters. All right. Ms. Sturgeon, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your name and date of birth for me, please?
Amy Sturgeon, and my date of birth is 1778.
78, okay.
Yeah.
All right. You got the, just lean, you're leaning down so the microphone's getting too far, so it's harder to hear you, Ms. Sturgeon.
Okay.
All right, Ms. Sturgeon, you're here in 25 CF 1510, where you're charged with possession of a controlled substance, 3rd-degree felony, possession of a prescription drug without a prescription, or what we call a legend drug, which is a 2nd-degree misdemeanor, 2 counts of that, as well as possession of drug paraphernalia, which is a 1st-degree misdemeanor. Do you understand what you're charged with?
Yes.
All right. I've been handed a plea and sentencing agreement that would have you plea to each case, or each count. On count 1, 2 years of probation with a substance abuse evaluation and counseling, or comply with the Emerald Coast Life Center program. Waive cost of supervision, $515 in court costs, $100 cost of prosecution, $100 PD fee, and a $50 application fee. But on the other three counts, the prescription drug counts as well as the paraphernalia, it'd just be time served and you wouldn't be on probation for those.
Okay,
Is that the agreement that you've made?
yeah,
Did you go over this sentencing agreement with your lawyer?
yes,
Did you understand it?
yes,
And did you sign it?
yes,
Are you satisfied with your lawyer's work for you?
yes,
Are you currently under the influence of any alcohol, drugs, or controlled substances?
no,
Are you suffering from any mental health issues right now?
no,
Has anyone forced, promised, or threatened you in any way to get you to plea?
no,
Do you understand that by entering a plea, there won't be a trial?
no. I mean, I understand.
You understand that there will not be one? Okay.
Yeah.
And do you understand you're giving up your trial rights, which are on page 2 of that agreement that you signed?
Yes,
All right. And do you understand that if you're not a citizen, you could be deported because of this?
yes.
I didn't see a score sheet.
I mean, I'm a citizen, so,
Well, I can't ask that question, so I have to advise everyone of that.
okay.
Did I not give you one? Okay, I apologize.
I don't see it in here unless it got scrambled inside of this.
I will print one out. It's, she scores 19.6, Your Honor. TSP, now, yeah, she
Total
doesn't
sentencing
score
points.
prison.
All right. Ms. Sturgeon, what is your plea in this case? Are you pleading no contest or not guilty?
No contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, and knowingly given. I'm going to place you on probation on count 1 for 2 years. You're going to do a substance abuse evaluation and any recommended counseling, or comply with ECLC. You're going to be adjudicated on all counts, so that's a felony conviction for you, Ms. Sturgeon.
Okay,
Waive cost of supervision due to the fact that you're indigent, $515 in court costs, $100 cost of prosecution, $100 PD fee, and $50 application fee. Anything that I've missed? All right, I'm going to have you go talk to probation, then I need you to be fingerprinted, and then you have 30 days to appeal.
okay.
Thank you, Ms. Sturgeon. Yes, sir.
I've got you now.
Okay.
It's all right, thank you.
Yes, you gave me this. You're good. All right. You'll need to sign it right there. Reinstatement fee. Your Honor, this is Robert Frederick Floyd Suttles before the court on 25 CF 151, 25 CF 1467. We've reached an agreement, if I may approach.
These are both new cases, right?
Yes, Your Honor.
All right, Mr. Suttles, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Robert Frederick Floyd Suttles, 1989.
All right, Mr. Suttles, you're here in 25 CF 151, where you're charged with possession of a controlled substance, third-degree felony, possession of drug paraphernalia, first-degree misdemeanor. Also, you have 25 CF 1467, where you're charged again with possession of controlled substance, possession of drug paraphernalia, and resisting without violence, which is a first-degree misdemeanor. Do you understand all that?
Yes, sir.
I've been handed a plea and sentencing agreement that calls for you to plead no contest as charged. It'd be adjudication of guilt, which is a conviction in each of those cases, including the 2 felonies, 6 months in the Okaloosa County Jail with credit for time served, $515 in court costs on each case, $100 cost of prosecution on each case, $100 PD fee on each case, and a $50 application fee in 25 CF 151. Do you understand all that? Is that what you want to do today? All right. Did you go over this plea and sentencing agreement with your lawyer?
Sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled
No, sir.
substances? Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressure, or threatened you to enter this plea?
No, sir.
Anyone promise you anything in return for your plea?
No, sir.
Do you understand by entering a plea there won't be a trial and you're giving up your trial rights, which are on page 2 of the agreement you signed?
Yes, sir.
Do you understand you're waiving all potential defenses that you may have?
Sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, what is your plea as to each of those 5 counts?
No contest.
I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty on all 5 counts. Adjudication of guilt, 6 months at Okaloosa County Jail, credit for time served. On each case, it'll be $515 court costs, $100 cost of prosecution, $100 PD fee, and a $50 application fee in the 151 case. This is a guideline sentence. You scored 38.2 points. I'll need you to step up and be fingerprinted, Mr. Suttles, and then you have 30 days to appeal the judgment and sentence of this court. Oh, and you'll have 90 days from your release to pay your costs or set up a payment plan. Otherwise, it'll be a judgment against you.
Your Honor, I have another matter before the court.
Okay.
Byron Williams.
Mr.
Jr.,
Williams?
25 CF 1131. He is present, Your Honor.
Okay.
Your Honor, we filed a motion to withdraw from this case. Mr. Williams is charged with robbery with a firearm, grand theft of a firearm, and he was additionally charged later with another charge, but at this time, on June 1st, he had first appearance. The judge ordered the 72-hour hold for the state to file a motion for pretrial detention, and the court set his bonds, each count $50,000 for a total of $100,000. 72 hours later, Mr. Williams posted the $100,000 professional bonds through Billy Clark Bail Bonds. He does not meet the indigent requirements under Florida statute, section 27.52. A person is presumed not indigent if they have assets more than $5,000. And I cited in the motion the Hagwatt versus Bullar case that talks about the court may not appoint the public defender represent a person even on a temporary basis, a person who is not indigent. And so that is the motion that I'd filed with the court.
All right, Mr. Williams, can you raise your right hand? Do you swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth, please?
Byron Williams, 2006.
Okay. Hold on just a second. All right. Who posted your bonds, Mr. Williams?
My parents.
Okay. And how old are you?
18.
All right. And so who is Johnny Perkins? Oh, that's the bondsman. I'm sorry. I'm just trying to read the names here, but
I couldn't see where it said who did it, Your Honor.
are you currently working, Mr. Williams?
I just got hired at Chili's.
At Chili's?
Yes, sir.
And how much do you expect you're going to make a month?
I'm not sure.
Okay. Well, how much are you going to be making per hour?
Say they said 15.
$15 an hour?
Yes, sir.
Okay. Do you expect to work full-time, which means 40 hours a week?
Yes, sir.
Okay. And so your take-home, or your gross pay would be about $2,400, but your take-home will be a little less than that. Do you have any dependents?
No, sir.
Do you live with other people?
Yes, sir.
Your parents?
Yes, sir.
Okay. Do you have any assets as far as a car or bank accounts or anything like that?
No, sir.
All right. Do you drive a car?
Yes, sir.
Who owns that car?
My parents.
Your parents. All right. So do you have access to any funds whatsoever other than what you're going to be making at Chili's?
No, sir.
Okay. Any issues, Ms. Rivers? State doesn't have any concerns?
No objection either way, Your Honor.
So I'm going to deny the motion, but I want to make sure you understand, Mr. Williams, this is not something that Ms. Rivers, does because she doesn't want to handle your case. It's just
Yes,
she's
sir.
required to do this when you pay a large bond like you have.
Yes, sir.
Because, that would have cost, well, I don't usually try to get involved in this, but my understanding is not every bondsman necessarily charges 10%. So
Yeah.
without getting into those facts, I've seen people put up their properties and things like that. So since he doesn't have access to anything else, I would almost equate this to when people hire a private lawyer and then ask for them to be found indigent for costs. There is an availability for that, Ms. Rivers. So I think based on what I've heard today, I'm going to go ahead and then deny the motion to withdraw. All right, what's the next court date that we have from Mr. Williams? 10/27. So we'll see you back on 10/27 at 1 o'clock.
Yes, sir.
All right, thank you, Mr. Williams. You too.
Thank you, Your Honor. Your Honor, the only other thing I have left